Good morning. Good morning. Good morning, everyone. Afternoon, evening. I don't know. Welcome to a messy Monday, right? I would call it Monday mayhem or Monday madness, but I think it's going to be a messy Monday, and that's okay because I got y'all, right? Hey, Sherry's Life. Hey, Fala. Hey, Steven. Hey, Baca. Hey, Fala. Hey, the Jules. Hey, Nanny. Hey, Pretty Brown. Good morning. Good morning. Good morning. Let me see. I don't want to miss anybody, but if I miss you, don't take any harm to it. Good morning, Benny. Good morning, Rachel. I'm scrolling backwards. So y'all know how that can be on this messy Monday. Hey, Queen. Hello to anybody that's in the chat room. Hey, Libby. Good morning. Good morning. Good morning, Pinky. Good morning. I tell you, I would be much more in tune with things. Like I knew this stuff with Court TV was gonna kind of happen in some type of way, and that's why I scheduled the stream for later today versus to our early start time, even though the case is coming out of Georgia. Because of course they're doing jury selection. Hey, fam, good morning. Right? So they typically don't stream the jury selection, but I got some stuff for us to actually look at. I know most of us don't know anything about this case, right? We kind of talked about that yesterday. So I was able to get some court documents pulled up for us that we'll review to see what is exactly going to be happening in this case. So that's what I was doing this morning, doing all my homework, trying my best to have something for us, right? Like we can't just sit here and do nothing. And hey, film. Guess what came through my thing this morning? Of course, Florida will never let us down. So they have this trial. They are also in jury selection today. It is a retrial for Sheila Aggie, right? She heading back to court for her retrial because the first trial ended up in a mistrial. Thanks, Pinky. So her retrial starts today, and they're reselecting the jury, right? And this is like the most bizarre. I don't want to say bizarre, but it's kind of strange because if y'all don't know the history, her son was convicted of literally walking into the Home Depot, unaliving the girlfriend, leaving the scene, later turning himself in, and they say the mom convinced him to do it. Hey, South Africa. I think that's the first one that on the scene. Hey, Miralinda. South Africa. Whoa. Welcome, welcome, welcome. We're reaching them all, right? We all over. Wow. Yeah, so I was like, when I seen that one, I'm almost sure they're gonna stream it. I think. So we kind of like touch and go. So far as I'm concerned, whichever courtroom allow us in is the courtroom that we going in, right? We gonna be in there, and we'll just figure out how to switch between the two if that happens. But I was like, wow, like, and he went and unalived her because he was upset that she may have she gave him a STD. Thank you, film. Now y'all know. Now y'all know y'all gotta put a name on it. and tell thank you, film, for the he then gave somebody a drama docket, right? Membership. The names must be named over here. We must spam the chat with a thank you to film. I'm started, but I'm not started. Just so y'all know. Started, but not started. I'm giving out teasers, Rachel. Hey, Palolo's mom. Pilolo's mom. Good morning. Good morning. Afternoon, evening, wherever you watching from. Hey, Kelly. Awesome, awesome, awesome. So let's see here. So let's start here. Oh, look at OnlyFans. Check it out. Thank you, OnlyFans. Now, you know, if you received that membership from OnlyFans, you got into that drama docket, right? Please make sure you spam the chat and say thank you, OnlyFans. Oh, and look at him. There you go again. He just sent out 2 of them. He gifting. It's not even Friendship Day. It's long past, and OnlyFans gifting them this morning. He said, good morning and welcome to this messy Monday. Right? This messy Monday. Thank you, thank you, thank you. So I think what we're going to do is we are going to go into these documents. And we are going to get prepared for what we should expect in this trial. See, right? I don't know about any of you guys, but whenever I can find documents and whenever I get documents, I am truly excited, right? So let me get our first document up that we are going to look at. And I think it's very important that we kind of discuss what charges we have. Let me see, because I have the court website up. So, and I don't know if any of you guys know, and y'all can let me know, but I believe, and y'all can correct me if I'm wrong, the attorney that is representing Nicholas is Douglas Weinstein, right? Is that Young Thug's lawyer? Was he in? He wasn't Young Thug's lawyer, but he was in the YSL case, right? Or am I thinking of someone different? Because remember, this is all coming out of near Atlanta. It's in Georgia. Georgia. Okay, Libby said that's right. Okay, when I was looking, I was like, oh, this name's here, right? So he a big attorney. We can agree upon that, right? After being that young thug, YSL, 365 day plus trial. I guess it was 365-day trial, but I may be exaggerating. Okay, so this what we got. Nicholas, right? I'm gonna call him Nicholas James because I'm not about to be playing around with this last name. So he is on trial. He's in Liberty County, Georgia. Georgia, right? And he charged with the second degree unaliving of his wife, Mindi, right? Whose body was discovered scattered across two wooded areas. Now, she was actually on the run with him during this period of time. Now, what they were on the run for, I have no clue. But I guess maybe he was tying up loose ends. Who knows? But his major charges that he has against him is malice, unaliving, right? He has felony, unaliving, aggravated assault, and then concealing an unaliving. It sounds so funny just seeing that, right? When I'm reading these documents, so I'm trying to slowly do it so I don't. So Google, look, I'm about to say Google. So YouTube don't think I'm trying to say the M word or the K word or the whatever word, right? Hey, just be nice. Good morning. I I know. Just be nice is really really funny. Got to watch our M words and our K words as we're in the chat. So let's be careful, guys. A dude that ended up not guilty on everything. Okay, Libby, you talking about the person that Douglas Weinstein represented in the YSL case, right? Motion detected at front door. Okay, so let's start here. Besides me trying to drink my water. So I think that we'll start with the state's first supplementary discovery disclosure. We'll go over what evidence that they have on this. I do have a second one. So we'll go over this one first. And then we will go over the motion in limine, right? Yeah, he was a lawyer, right, therapist? Motion detected at front door. Okay, so hopefully y'all can see my screen here. So this is the first document that we'll go over, just to kind of see what information the state has and what information they're going to present. Now I can tell you that the motion in limine that I do have pulled up from the defense, it has a lot more details and information. He is currently in custody. For those that are not aware, he was given a bond. He just was unable to make it. Okay, so he's still in custody, for what that's worth. But just so y'all kind of know, I'm just moving some of this stuff off my screen because I got every document that could be a document, that was a document that I was going to use, all up on my screen. So before I get all the way confused, well, what stuff we're taking, what stuff we're going to be reviewing, I definitely want to make sure. Yeah, I got his witness list. You don't have many witnesses that he's going to be calling, but I do have it. Let me get. Okay, so as we can see here, we have our state of Georgia, our defendant, right? Got our case number. Y'all know all that good jazz. We can see that. So they provided the following material to the defendant and the defense. They provided the investigative case summary on an interview with Natalie, right? There's also an audio interview that they provided. Blood examination crime lab report. We have a curriculum vitae with Edward Brian Mondor. I have no clue who these people are. We have a 2-mark examination crime lab report, GBI bench notes, and we have transcripts of an annulment hearing. And then we have an investigator supplemental report, right? So these were delivered to the defense, and that was their first list. Well, not their first list. This was the first supplement of their discovery in this case, okay? So we have that. Now, why the first supplemental discovery is kind of minute compared to the second one. And let me show you the second one. Let me get that up for us. So this is the second one. And mind you, this was just filed on July the 9th. So it hasn't been that long ago. And then we're going to see the paperwork that the defense filed after this on how they trying to say, hey, certain evidence shouldn't be put in here. We should limit certain photos. So kind of getting the back end. Okay, guys. So we have on here on our report, and OnlyFans, yeah, I kind of figured that. So we have on here, they presented to the defendant the following material. So number one, they want to present 5 photographs of Mindi, who is the victim. So let's keep that in mind. She's the victim in this case. Number 2, business records from Sony Pictures Entertainment. And then they want to they submitted revised business records. I don't know. Did he work for Sony Entertainment? I wonder what business records they need from Sony Entertainment. Yeah. Yeah, Sherry, a poison report. Yeah, he definitely was. So we also got the business records from J.C. Lewis Ford. Yeah, he did owe the ex-wife money. You're absolutely right, Rachel. So maybe that's where those business records are coming in. So we have the autopsy report with notes that was submitted. We have the alcohol content report, work product and notes. We have a toxicology, right, report. We have DNA typing report. We have a 2-mark report. We got a processing report. We got all types of reports. We got a blood exam report, LP processing report, DNA percentage report. Because remember, they had to identify her by getting DNA samples from family members. That's how they were able to identify her. So I think they did like an ancestry test or something to that effect, from what I remember. We have a DNA typing report. Of course, we got some old case information. Got 2 of those reports, one from FB Ransom and Dr. Lenham. We got this blood examine report. We got a poison detective report. Wow, they got a lot of stuff. Another poison detective. We got Brett Dickerson's curriculum. Got a final report from the ME. Evidence information. Case communication. Which, you know, I know that this is letting us know what key evidence will be revealed, especially when we're talking about the interview with Natalie, right? And those crime lab blood reports are very important. Hey, Cinnamon Bear. They are currently doing jury selection this morning. So I'm not sure if we are going to go right into opening statements. Keeping my fingers crossed. Definitely want to get us in the courtroom as soon as it happens. And of course, they always trying to, we need to have photos and text records and things like that. So the discovery just shows how the prosecution is linking our guy Nicholas, to this crime. So what else we got on here? We have our GBI bench notes, transcripts of the annulment hearing. Of course, they want to show exactly what he owed the prior wife. And just so you know, from my understanding, he did get married after this incident, right? This alleged incident. So this stuff was all sent over to the attorneys, of course. Now, it's to my understanding that the state plans on calling a total of 10 witnesses, just in case if anybody wanted to know. So that's what I have on the witness list. I won't show the witness list only because it has everybody's address on here. I don't know how that works. I have to figure out how that works in regards to showing. I was like, it got everybody address on it. I don't want nobody to talk about I gave out the address. So I'll leave that right there. And it's not, unfortunately, I got it straight from the court's website, so none of my stuff is redacted. Not that I mean, I personally don't need any of one. So right here, we'll go into reviewing over what the defendant is saying about all this evidence that they trying to bring in, right? Doug, like, we don't need to hear nothing from no ex-wife. She has nothing to add to this. Like, you don't have nothing to add to this at all. Like, that's old news, and it don't have nothing to do with him and his new wife. Right? So they filed this on July the 19th, 2025 in regards to it. So it reads, it says, comes now the defendant, Nick James, with a capital K, right? Through his counsel. We know, oh, Doug, right? They are respectfully, I mean, come on, court. Exclude all this evidence, all this documents, all this mess relating to his prior to marriage and his divorce from his first wife, like Heather, and her name is Heather Thomas. Like, we don't need that. That don't have nothing to do with this. Nothing at all. So they presenting, concerns in regards to the allegations. The defendant supposedly, quote unquote, unalived his second wife, Mindi, and dismembered her body and spread her over about 2 to 3 miles, right? In a wooded area. And some hunters found her body. She was found on December the 2nd, 2022 in Liberty County, right? He wasn't even arrested until May of 2023, and he was all the way in Pennsylvania somewhere living his best life. He was married to Heather, the person's testimony that they want to keep out, from 2009 to 2015. So this was like 7 years prior to the incident at issue, is what they're saying. His last interaction with his prior wife was in 2019, and that was following that $1.5 million judgment in a Virginia court that she was awarded, right? So, based on the discovery of the state witnesses, the state intends to introduce all this evidence regarding the marriage, divorce, and other court orders and communication between the ex-wife and Nicholas. They stand, but this shouldn't even be allowed in court. This stuff is character evidence, and it ain't got nothing to do with this case at all. So it's saying that it should be excluded up under that 404. We hear a lot of that in a lot of trials that we cover, right? So they're saying, yeah, we know they're going to argue that the introduction of this evidence is appropriate up under this 404B, including, but not limited to, proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of a mistake or accident. But they saying, no, don't put it in. So the defendant is just saying that this evidence is likely to be used, and it just shouldn't be, right? They're saying, like, I guess she has a quote that Nicholas is a terrible human and a terrible husband who mistreats all his wives, and I mean all his women. He don't want to pay him. He want to divorce him. He want to do all this stuff. And they're like, no. We don't want that in. That's bad character evidence, right? So they're saying that in the present case, they're giving some case information in regards to it, that it will provide improper arguments. So this is basically the defense trying to argue why we should not be able to hear from the ex-wife. So it says, even should the state be able to make it showing, the court will still have to decide up under this 4043 whether the value is outweighed by the danger of unfair prejudice, right? And then we get the information in regards to what this 403 analysis is done, right? Sherry said, I want to hear from the ex-wife. What she got to say? What do the new wife got to say? OnlyFans said she better get up on that stand and be careful, because if he go to jail, she don't get them dollars. What'd you say? Who cares about all them 404s? Oh, she testifying. Y'all don't have to worry about that. Hey, Kath, what do you mean when you say we have no idea what we're talking about? We're just reading the court documents. Welcome. You have additional information that you can share with us? Yeah, the new wife is not on here. They're fighting for the old wife. Yeah, they don't want the ex-wife to testify at all. So just reading on in their thing, they're saying that with the it's the state may attempt to get the defendant's character for mistreatment of the wives into evidence. So they must have some evidence, maybe from the ex-wife, that he was abusive or whatever the case may be, and that may be why why they got a divorce, right? However, the defendant's prior relationship with Thomas, which was 4 years and more before the alleged crime, is neither part of the same transaction as the charge offense. So it says necessary to complete the story of the alleged crime. Wait, so he has a judgment for him with his ex-wife, allegedly unalive his ex-wife too. And yeah, that's my understanding. He got remarried right after. Hey Kim, good morning. Not in and out. Them lines be wrapped around the corner. Yeah, he's definitely a busy guy. So yeah, so they basically submitted this on July the 19th, but it is definitely to my understanding that the ex-wife is going to take the stand. So whatever they thought they was going to get off, it's not going to happen. So let me send this over. So this was submitted to them on July the 19th, and I'll show you just how quick the judge decided, nope, it's coming in. So as we can see right here, this was July the 24th, 2025, right? Hopefully y'all can see it. They're just talking about the pre-trial hearing that happened that morning. It's saying that they dealt with this issue in regards to if the first wife should be allowed to, as evidence, their relationship be allowed to be evidence in this trial. Now, he ended his relationship once again, just letting y'all know, on the first wife, 1.5 million. The defense is arguing once again that there was a 3-year gap from the last point of contact, because remember the last time he spoke to her was in 2019. And these are separate issues. But his motive for him being on the run is what the state is saying. And he explains that the story all started because of this. Right? And a big part of the trial yet to be fully uncovered. But okay, so it says during and after his time on the run, Nicholas claimed that McIntyre was controlling every aspect of his life. But the state believes that McIntyre isn't a real person. What the heck? What is they talking about? I don't know what they talking about. They done lost me right there. What they mean it ain't no real person. He says all of this is an effort to explain why he and Mindi are on the run. Jim McIntyre, clearly, that wasn't his real name. Absolutely exists, says the defense attorney, Doug Weinstein. What you talking about, Doug? They were moving every few days at the control of this person. We'll keep calling Jim McIntyre. Is this the oh, he goes by 2 names? Well, get us together, Sherry, because I'm like, who is Jim? That's what I would like to know. Who is Jim? Seeing somebody name. Oh, so he done made up an imaginary person to explain why him and Mindi was on the run. I don't know. It say I can click. Okay, here are the full statements from both sides after the pre-trial. Well, it ain't okay. Whatever. So Doug says we look forward to the trial and finally be able to clear Mr. K's name. This trial is a long time in coming. Boom. Through no fault of any individual. But because he was over there handling that YSL young thugger situation, it caused it to delay. So now they finally glad. Doug said, look, I'm done with YSL. It didn't take 5 years. That case is over with. I'm up in here. Let's handle this. I've been waiting for this day. The Office of the District Attorney of Atlantic Judicial Circuit is also preparing for this trial, saying we hope that we're moving closer to justice for the family of our victim. Most importantly, Mindi, right? The trial begins today, which is August 4th, directly at the jury selection. So interesting. I guess, to say the least, in regards to that. Yeah, it looks like Court TV is still like playing a little rerun. I guess you can consider it like a promotional video, kind of showing that the trial is coming up. Yeah, but interesting to know what we got coming up with the trial. Let's see here. Are you reviewing the case info? I just read through the court documents. I think they'll seek the jury today, Kim. Fingers crossed. That is, right? Yeah, but I definitely think I just don't know how long it will take them to do it. You know, that voir dire process. I think it's called voir dire process. So if they finish that today, I'm hoping, in a respectable time, they'll allow for court. That's why I scheduled the stream to, of course, they're probably in court at 9:00, right? Which is like 6:00 my time. So I was like, well, I won't schedule it till later in the day to see if they can at least get through jury selections and we can kind of like play around until then. And then while I was in there, I was looking and I seen this other trial that they had coming up, because our great old state of Florida, Florida could not be left out of any week of trials. Like, they are just not playing that. Like, if anybody is going on trial, Florida people just can't lay down. They cannot rest without making sure that they got a trial going on. So shout out to Florida, because they just not gonna let it happen. So this is the other one, and I'll show y'all that one. Do you want to see the Sweet Pea merch? You email me some ideas. Film. Email me some ideas, because I have no clue. Let me show y'all this. So this is the other case. And quiet as kept, whichever one we get up in, that's going to be the first one we're going to be up in. And we will toggle. So this one, it was a mistrial before. And just so y'all know, this is coming out of Florida. They cannot let us down. Some t-shirts. Okay. Nanny, I believe that this is a life without prison. So this is our girl, Sheila. This is the mama. Her jury selection is scheduled also for today because Florida, of course, they got to make sure they up in the house. Like, they got to make sure they own Court TV every week. Like, it's just no way. They cannot let it down. So her son was convicted of unaliving after he went inside the Home Depot. All the cameras, everything around, didn't care, no disregard, and decided to unalive his girlfriend. Now, the mama, she went to trial for first degree premeditated unaliving in November of 2024. But the proceedings ended up in a mistrial due to strife amongst the jurors. Can you believe they had a mistrial because the jurors was acting a mess? Like the jurors was acting a whole mess. So her trial and new jury selection is scheduled for today. And here's a little bit of what happened in the first trial. So we can look at some of this. I guess we can look at some of them. Maybe we can't. I don't know. Oh, wait a minute. So the backstory on this one is on August 11, 2023, Sims, which is the victim, was working at a Home Depot on Davis Highway. She was doing inventory counter when her ex-boyfriend, Keefe, right, drove all the way from Alabama to unalive her. He walked right into the store. They say he headed right down aisle 52. They even got the aisle number. And fatally shot her. At least 7 times, y'all. And then he fled the store and turned himself in. Like he could have just stayed for that. So now during his 2023 trial, he testified that he was so mad at her after receiving a call at work on August 11th that he had tested positive for STD. For STD. He said he immediately left his job in Alabama and got right up and drove right on down to Pensacola, Florida. He said he was enraged, betrayed, and hurt about receiving this diagnosis. I can't with these people. Like, what is wrong with them? Really? He told the jury after hearing the news he intended to get revenge. This right here, this is the mama. You know, he was immediately sentenced to life in prison without the possibility of parole. But the problem is that texts indicate that his mama convinced her son to commit the unaliving in Pensacola. No. I want you to unalive her. Don't do it here in Alabama. Go ahead and drive up there to her job and take care of this. So prior to the shooting, the mother and son was on there with them Twitter fingers, right? Getting all that Twitter going on, those Twitter fingers. So they sent each other all types of messages planning this out. And so during her first trial, messages were submitted into evidence to show how Sheila and Keith, they came up with a plan, right? So no one He said, he texted the mama and said, I want to say this is bruh. Maybe he was calling his mom bruh. Bruh, that's another thing. If she don't get out the car, mama, and I have to drag her out, or can't, I'ma ask you to step out because I'ma open the door and just shoot her. Then the mama replied, hell, if you getting off work now, I'll give you the address here and you can ride over here and do it. So you don't have to do it in front of his daughter. Turn down my phone. I can't, Jules. That's my baby. I got to keep that one going. Yeah. So, wow. Check that out. So, him and the mama, these are text messages that they didn't pull from him and the mama. That ding just ding, my ding. I know. And it's so crazy when the kids, when they send me text messages, she just send me like 8 messages with one sentence. One word, not one sentence, one word. Let me see, because she is show texting me. Let me text her back. That way y'all don't have to hear the ding, ding, ding. Last time we was on stream and I tried to do that, what is it? The do not disturb on my phone. I couldn't get it off. So I'm too scared to put it on there again. I had to wait till one of the kids came home to take it off. Yeah, I got one. If she want to do cheerleader. So I don't know how to do this. Can I turn? I don't know. I don't know. I don't know. I don't know. Y'all don't want me to throw my phone. I can't put my phone in the other room because they may be they may need to call me. Life of being a mom, right? And a mom that's not tech savvy. So back to this. So we see the text messages that Sheila, where she replied to her son. This is Keith's text message. So he basically told his mom via text message, hey, I want to do this, but if I can't get her out of the car, I'm going to drag her out. I can't, I'm going to ask you to step out because I'm going to open the door and just unalive her. So after Keith asked for the address, Sheila gave him the address for the Home Depot. So if y'all wondering why the first trial was, yeah, the mama was really okay with this. Absolutely. She was okay. So why did her first trial end in a mistrial? You know, I hinted to y'all and let y'all know that it was kind of something with the jurors, right? So after both the prosecution and the defense rested their cases, now look, they had went through the entire case. They had rested their cases. They gave final argument on November the 2024. Judge Robinson declared it a mistrial after the jurors say they were concerned for their physical safety while deliberating. One of the jurors who spoke individually with Robinson in open court described a loud verbal disagreement between certain jurors while they were deliberating. Like the jurors was in the jury room arguing and fighting, right? She told the judge that she felt for her physical safety of the jurors were so out of control due to the argumentative nature of one of their fellow jurors. Like, how are the jurors back there and they arguing so much and can't get along to the point that the juror come out like, I'm cool on this. I fear for my safety. If I don't vote the way they want me to vote or voice my opinion, I might be injured or hurt. Have you ever heard of such a thing? The jurors said that some of the heated arguments during the deliberation became racially motivated, right? But it was unclear whether the remarks were directed towards the mom or another juror. The deliberations became so heated that they asked the court if one juror could be replaced by an alternate, which is not allowed in Florida's, according to their laws. So the former attorney, Chris Raby, mentioned that motion for a mistrial on the grounds that the jurors were fearing for their safety and possible racial bias, which would prevent his client from receiving a fair trial. I am so concerned it would not be a fair and just verdict, her attorney mentioned. While explaining to the jury he was declaring a mistrial, Robinson also denounced the action of one juror who was ordered to pay attention during the trial after it came to the court's attention that this juror was sitting over there playing crossword puzzles. This juror said she said, I ain't even paying attention to this mess. And I don't care what y'all say when we get back here. I'm going to do my crossword puzzle and I'm going to take it easy. Right? That same juror returned to the following day with another crossword puzzle. What a gangster. Said, just kick me off of here. I did not want to be here for $7.20 a day. I need to be out here making some money. I don't have time for this. I do not want to do this jury stuff. How did this person get this far into this trial? I have never heard of something so egregious. This is only in Florida. The jurors can't even get along. So they say during the following day with the other crossword puzzle, he was using it during the deliberations. According to the other jurors, like, I ain't got no interest in, I don't care what y'all vote. Y'all just do that. Y'all do whatever y'all want to do. I'm just here for the $7.20. I don't know how much they make an hour. $7.20 just sounds like some stuff that I want to say. So they say there is a particular juror who has not treated this case, and it's evident with all seriousness it should have been. They even addressed the juror, and it continued back in the deliberation room. So, of course, they did grant the mistrial. The attorney, he withdrew. He was like, this is going to be a lose-lose situation. I'm cool on this. So he cited that his clause in their contract that excludes representation for any retrial. So he said he had a clause in his contract that, hey, I'll represent you in the first one, but if anything happens and we can't get through it, I'm cool. You need to find you a new attorney. So Robinson, the judge who presided over the first trial, he said, I'm cool on this too. Y'all find a new judge. So he will not sit on the bench for this second trial. We got Judge Amy, who is expected to preside over this case. Now, if you were talking about a mess with a case, now if that ain't a mess with a case, I don't know what is a mess with a case. Like, that is such a mess. I mean, what a mess. Give me 1 second. I'm gonna check something real quick. God, and he was a little cutie pie, but I just don't understand. I mean, he a little young for me, but he could be like, he doable. Let me see. Here, I'm gonna show y'all some of his testimony. Wow. So I'm gonna put on some of his testimony from this trial. Yeah. Oh, I definitely hope they stream this one and do it right. But wow. Oh wow. Okay, here we go, guys. Oh, dang. Is that what you do or not? Only fan I'm over here looking at this stuff. Thank you. Thanks, Zach. If y'all got that gift from OnlyFans and you got that drama docket membership, you know what you need to do. Put the names must be named. Thank you, Zach. You sure? You sure you want that crown, right? Okay, let me play this for us and let's hear what his testimony was.
So raise your right hand. You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth. So help you God. Yes, sir. Let's have a seat.
All right, I've been pointed out several times today, but I want you to state your full name for the jury and spell your last name for the record.
Keith Eric Agee, Agee.
How old are you, Mr. Agee?
I'm 20 years old.
Where are you from originally?
Calvert, Alabama.
You were living there at the time of this crime?
Yes, sir.
Were you employed?
Yes, sir.
Where did you work?
I worked as a steel operator for AM&S Calvert.
How long have you been working there?
I just started recently, 2 months prior to this.
Do you know the deceased Brooklyn Sims?
Yes, sir.
How long have you known her?
Approximately close to 3 years
How did you two meet?
through mutual friends.
What was the nature of your relationship?
We were boyfriend and girlfriend.
Consistently the entire time you've known her?
On and off multiple times during the 3 years.
Do you have any children together?
Yes, sir.
How many?
One.
How old?
She just turned 2 in October.
What's her name?
Casey.
You two live together?
We have multiple times in the past.
Were you living together at the time she died?
No, sir.
Were you two together at the time she died?
Not officially, but we were going back and forth romantically.
When was the last time, when you say romantically, does that include sexually?
Yes, sir.
When was the last time you two were together sexually, romantically?
The prior weekend from August the 11th.
The weekend before she died?
Yes, sir.
How did you spend that weekend?
We mostly stayed watching movies, joking and laughing, and playing with my now 2-year-old.
You two were co-parenting together, is that fair?
Yes, sir.
Well, I'm gonna quit beating around the bush now. You killed Brooklyn Sims.
Yes, sir.
You're the one on the video at Home Depot.
Yes, sir.
Let's walk through that day. How did the day begin?
It started off as any other average morning. I got up for work early, got dressed, and started my day and proceeded to work.
Did you have to work that day?
Yes, sir.
Well, the state's introduced text messages between you and your mother. Is that correct? That was between you and your mother?
Yes, sir.
Did at some point that day you discover you had been diagnosed with gonorrhea?
Yes, sir.
How did you find that out?
I received a call from Greater Mobile Urgent Care.
When had you taken an STD test?
The before Tuesday to that date.
Tuesday prior to the shooting?
Yes, sir.
Why did you have that test done?
I started experiencing abnormalities that I've never had while peeing and resting and sitting down.
Had you ever had a sexually transmitted disease before?
Never in my life.
Other than the weekend, was that immediately after the weekend you had spent with Brooklyn?
Yes, sir. The following Tuesday, I got a test.
Had you been sexually active with anyone else?
Not for almost 2 months with anybody else.
After receiving this information, what did you do next?
Proceeded to leave work and head straight to my house.
What did you go to your house for?
I went to retrieve my firearm.
How long were you there?
Not approximately a minute and 30 seconds. So maybe a minute 15, a minute.
That was a very
I left my car running. I ran in the door, jogged back out.
Did you let anyone else know about your diagnosis?
My mother,
Why did you tell her?
because I knew that she and Brooklyn worked close in hand. I knew they worked the same job and they talked back and forth a lot.
you know where Brooklyn was at that time?
Not till my mother informed me.
Do you recall driving the drive from your home to Pensacola?
I don't recall the whole trip. I recall spots of driving.
Let me back up a bit. After you were informed you had an STD, how did you feel?
Enraged, betrayed, hurt.
And the text messages are in evidence. You intend to get revenge on them.
Yes, I intended to.
When you arrived at the Home Depot, was it your intention to shoot Brooklyn?
Not fully. And what I mean by that is I was enraged until I arrived on aisle 52. When I got to aisle 52, seeing Brooklyn brought sort of a sense to me, brought me back down to earth, you know, being hot the whole way there, driving mad, seeing her kind of brought me back down to earth. So I remember pointing out my finger. I never got close enough even to touch her. I said, "Hey, you gave me something." And she said, "Not this again," and turned around and proceeded to walk off from me.
How did that make you feel?
I've never been so mad in my life.
What happened next?
I pulled my firearm from my waistband and I proceeded to shoot Brooklyn.
That's 1 second, Alan.
Yes.
Mr. Agent, do you have any remorse?
Objection.
How did you feel when she turned her back on
Hurt, betrayed, mad.
you? Tell Brooklyn if she was here today.
Objection, Judge.
Sustained.
No further questions.
Any questions?
Yes. We heard testimony earlier today that Calvert is 2 hours away. Is that right?
For the average trip, it didn't take me 2 hours.
How long did it take you?
Anywhere close to around an hour and 30.
So 1 hour and a half. It took you.
Yes, sir.
Did you stop anywhere along the way?
I think I stopped to get gas along the way.
Did you not stop in Loxley?
I think that's one of the stores I stopped by. I can't recall.
How many stops did you make?
Only one.
So why do you say one of the stores you stopped at?
Because I can't approximately remember what store I stopped at along any of the exits. I'm not too familiar with any of the area going further around Loxley. Anywhere past Mobile Bridge.
Any idea how many exits are between Calvert and Home Depot?
I'd say about 20 maybe.
28. Now, you got the phone call that morning from your doctor saying that you tested positive for the gonorrhea, right?
Yes, sir.
And you said you were at work when that happened and you went straight home and that you heard that was your grandmother's house, right?
Yes, sir.
How far was that from your work?
It doesn't take me 2.5 minutes to leave my job and get to my house.
You said you weren't in the house, but a minute and a half, you said?
Yes, minute and a half. Yes, sir.
How do you know it was a minute and a half?
I remember leaving my car running, and from a park close to the house, and it's not 15 feet from the front porch to my room and back. And I jogged in, jogged out.
All right, you went straight to your room, you got your pistol.
Yes, sir.
That's the same pistol we saw earlier today.
Yes, sir.
Was your grandmother home?
Yes, sir.
Did you talk to her?
No, sir.
And you knew Brooklyn would be with your mother, but you didn't know where they'd be working, right?
Yes, sir.
And you got the address from your mother.
Yes, sir.
So when you got the phone call from your doctor, you automatically assumed Brooklyn gave it to you, right?
Yes, sir.
So your testimony is that you drove an hour and a half after getting your pistol. You got the address from your mother. You went straight to the Home Depot, right?
Yes, sir.
Didn't stop anywhere in Pensacola.
No, sir. I didn't stop in Pensacola. No, sir.
So you went straight to the Home Depot. You parked your car actually next to your mother's car, right?
Yes, sir.
You left your car and you went up to approach Home Depot. You saw the video earlier, right?
Yes, sir.
Okay, you had your phone out.
Yes, sir.
What were you looking at?
Nothing. My phone was just in my hand from being in the car. I had GPS on because I didn't know my way through Pensacola or how to get to Home Depot.
When you were in the parking lot and in that store, did you not look down at your phone?
I can't recall.
Was your mother telling you where she was?
No, sir. Not in the store.
Did
No.
she drop a point to you?
She told me on the way to Home Depot that they would be in Home Depot.
Did she tell you what aisle?
No, sir.
Did she drop a point to you?
No, sir.
You entered the Home Depot in the main entrance and you walked directly to aisle 52, right?
No, sir. I walked along the aisles looking. I didn't know which aisle exactly that she would be located on.
You didn't stop and talk to anybody?
No, sir.
You went straight to her.
Yes, sir.
You walked down, once you saw her, you walked down the aisle and you said, you gave me something.
Yes, sir.
She says, in your words, not this again, and turned away from you.
Yes, sir.
You said on the ride over here, this hour and a half, you were enraged, betrayed, felt hurt, right?
Yes, sir.
And you said you saw Brooklyn and it all melted away.
Yes, for that brief moment. Yes, sir.
How long was this brief moment?
Until she turned away from me and said, not again.
And then you said again, you felt hurt, enraged, betrayed. The same thing you just said.
Yes, sir.
Never been so mad in your life
Yes, sir.
because she turned away from you.
Yes, sir.
And you were going to teach her something.
Yes, sir.
And that's when you pulled out your pistol and you shot her. And you had no idea how many times you shot?
No, sir. I can't recall approximately.
Did your gun jam? We saw it jam.
No, sir. Not that I recall.
That's all that just said.
Redirect.
Would you have shot Brooklyn if she hadn't turned around, turned her back to you?
No, sir.
So we can step back then. Mr. Watts?
A mom and dad are murdered while hiking with their
Which is like, wow. Like no care, no regard in regards to it at all. Like no remorse. Just no. I'm trying to see if they had anything else on here that would be interesting for us to see. And y'all know, quiet as kept, I see in here, he never even had a STD. Oh, the victim never had a STD, so she didn't give it to him. Oh my goodness. Not to say even if he did, like that would be something that he could be out here doing it for, but like really? And I'm still keeping an eye on all our courtrooms to kind of determine. Let me see. Oh, okay. And she was the mother of his child. Oh God. This is this is unbelievable. I mean, unbelievable. And to know that the mom was encouraging this. I'm just looking to find us a good video, possibly, if I can find one. To give us a little bit more background on it. Because as I'm scrolling through here, I am finding more and more like tidbits of information. I mean, like he went all the way in the store. Like you got to be so mad. Like he wasn't even waiting for her. He wasn't even gonna wait for her to get off work. Like with all the cameras at, like you big doofus. Maybe. Let me share this one.
And he said that the mother of his 2-year-old daughter, well, he basically said that she gave him this STD. He went to her workplace at a local Home Depot, and he shot her. And everybody saw that video.
And of course, he testified. We played that. He admitted to shooting her in a very odd way. It was like he was smiling at times as he was remembering
Very
this
robotic.
with pleasure. It was really disgusting. Let's take a watch at the verdict.
In the Circuit Court for Escambia County, Florida, State of Florida plaintiff versus Keith Eric Aji, defendant. Clerk number 1723CF003379A, Division A. Verdict. We, the jury, find as follows as to the counts charged in the indictment. Count 1, guilty of first-degree murder as charged. Count 2, not guilty. So say we all this 20th day of December, 2023.
Okay, of course, after that, it was right to the sentencing phase, and Brooklyn Sims' mother testified. She was very emotional, and take a look.
The actions of Keith A.G. greatly impacted my life. As some of you may know, Brooklyn was my friend and co-worker that I formed the bond with rather quickly. To know Brooklyn and to love her. She was my always smile, a smile that was brighter than a sun. She had a voice that you could decide who your eyes played. Brooklyn was a daughter, a sister, a friend, and most importantly, a mother. Seeing Maison's face, I couldn't consider it always brings tears to my eyes. Because not only did she lose her mother, she lost her father and her grandmother as well. She had to grow up with neither parent in her life, and that would hurt me the most. Every morning I wake up, Brooklyn crosses my mind, and I cry because she didn't deserve what happened to me. I always cry to take my breath away and make my chest hurt. It's been countless of nights I sit up and I think about Brooklyn and her family. Since the day of August 11th, I've had a hard time going to places that consist of a lot of people. I constantly watch over my shoulder, afraid that what happens to Brooklyn could one day happen to me. I've had a hard time sleeping at night since this history due to the constant visions that play in my head watching me get that burn and never get back up. I'm no longer able to trust the people that before this incident I thought I could trust. Because this made me see that even the people closest to you are harming you in the most foul ways. I've had a hard time with any loud noises and banging and loud noises in general because it reminds me of those gunshots that I can't seem to get out of my head. This incident also caused me to have to go to the hospital by ambulance and also caused me to miss work for the time of my healing. I returned to work a week after the incident simply because sitting at home thinking about this put me in a bad space mentally. I was told by the doctor that any inch closer, the bullet could have went all the way in. And to think before Mr. A.G. walked on that aisle, I just moved over to the next man's partner. People should not be able to commit these crimes and get away with it. The emotional impact of this will be felt for years to come. I'm grateful for my friends and family that were by my side at the time of this incident to help with my physical things that I needed and still to this day for any mental and emotional support. I deeply feel that Mr. A.G. should be held accountable for his actions.
My name is Cornelius Vanessa.
How are you related to Brooks?
I'm working with his mother.
Now we're here for sentencing for Keith A.G., right?
Yes.
Okay, you got some things you want to tell the judge?
Yes.
Go ahead.
Obviously, a lot changed my life. I lost my dog. Her siblings lost a sister. She was an auntie. She was a friend. She was an amazing child. She didn't deserve it. I'm not at the point in my life right now. I don't hate Mr. A.G., but I can't forgive him for it. I'm raising his daughter. That day, Casey lost her mother, her father, and her brother. I know that life without parole is on the table for him. Maybe he'll be able to get himself together for cases. because one day she's gonna ask me about this, and he is going to have to explain that to her. That's it.
All right, that was the victim impact statements. And when this was all done, something crazy was revealed. Like, remember that supposedly the reason he was going there was because she gave him an STD. Well, guess what? We're gonna take a break and tell you.
Give it away.
Yeah, it was a bombshell, a final piece of evidence. Don't want to miss it. Stay with us.
Tonight on Court TV. These are the big cases that everyone is talking about.
A lot of new developments taking place.
Shocking,
I know who killed John Bonet.
to say the least.
You cannot make this stuff up.
It's unreal. The scene of the double murders is behind us right here. Things are happening. The investigation is continuing. Closing arguments with Vinny Politan. Tonight at 8/7 Central. Only on Court TV.
How did you feel when she turned her back on you?
Hurt, betrayed, mad.
Welcome back to Court TV Live along with Chanley Painter and Ted Rollins. We have been watching the end of the murder trial for Keith Agee.
That's right. A jury found him guilty after about 3 hours of deliberations yesterday of first-degree premeditated murder for the death of 18-year-old Brooklyn Sims. And he took the stand. He told the jury that he did, in fact, shoot Sims in the heat of the moment after finding out he tested positive for an STD after he had been intimate with her a few days earlier.
Yes, and then a major bombshell in this trial. After the verdict, the state submitted one little final piece of evidence, and boy, it really throws this whole thing into another layer of disgustingness. Take a look.
Some pictures of Brooklyn's daughter, Casey.
Judge, and one last thing, I really want to put you through the evidence because it has some medical information from Brooklyn Sims, but I showed Mr. Weissman, who has an objection. Judge, this is an extract.
You know, like this is like stranger with every minute. Like the more and more I keep watching this, and then to find out that the mom is involved in it. Like he did all of this. Like, first of all, like when I first looked at it, I didn't know how detailed and how in depth this was going. Not only did the mom convince him to do this, the mom, from my understanding, dropped the girlfriend off at work. This is the mother of his child, right? And then it turns out that she didn't even have a STD. It sounds like he the one had it. So that means that he was out here creeping and crawling. Like, how dare you? No matter what it is, I'm not ever saying that it's okay to, do anything, but really? This is what we doing out here? But let's see what else. And this is just his trial, right? Because we know all the stuff that happened in her trial. The jurors was back there fighting. We got one back there doing the crossword puzzles. Like, I don't have time for this. I don't care nothing about this. Y'all do what y'all want to do. To the point that it got really bad back there, right? But let's see what else we can find out in regards to it. Yeah, right, Pretty Brown? Definitely out there raw dogging, right? And got the nerve to come back to her. And yeah. Let's see.
Report from Shooter Agee's cell phone number, and there are just some text messages between her and Brooklyn.
And the court would look on page 4. Brooklyn sent a picture of the doctor's appointment she had on August 5th. And if you look at the very last page, it just shows that Brooklyn actually did not have gonorrhea. And I know in the grand scheme of things it doesn't matter, but we just wanted to give Ms. Sims a little bit of dignity.
Any other witnesses read this?
No, Your Honor.
Stacy, please.
No, Your Honor.
She didn't have gonorrhea at all in the first place.
She didn't even have it.
Ugh.
It died for absolutely nothing.
Yeah, horrible. Josh Schiffer and Jack Rice still with us.
I mean, of course, nobody wants to have an STD, right? But dang, this was treatable. Come on. She didn't even have it. And even if she did have it and he had it, this is something treatable. Like, right, only being like, come on. Right? Okay, you say, yeah, like, really? And this is the mother of your child. And then the mama, she the oldest one with not even a thinking cap on her head, talking about go do it, go do it, go do it. Let me give you the address. Don't do it here in down here in Alabama. No, go to Pensacola and do it. Don't do it down here where we're in our stomping grounds. Oh my goodness.
Yeah, I mean, unbelievable. This case is so sad on so many levels. Josh, you first.
It's the example. Okay, pointlessness of that. And then you pull that rug out from under this, and it makes it just feel hollow, even more pointless than it was previously. And that's really the difficulty that we face sometimes, because the motivations behind people, their justifications, and then their ability to get access to some instrument, and that can be a knife, a gun, their own hands, and then to not be able to control themselves. And you want to be able to say, I just want to stop you and tell you this one thing as we watch this. And that's really the tragedy, because when we deal with this on a daily basis, as we walk into courtrooms, as I did just this morning, you realize that so much of this could have been stopped. So much of this could have been addressed earlier on. But once you get down a certain path, then you're stuck with these facts, and you watch them and you think of these family members during their victim statements and what they've lost.
Are bringing you the end of the murder trial for 20-year-old Keith Agee. We watched that play out last week here on Court TV.
Yesterday we did.
This week,
Yeah,
actually.
it seems like last week. I know. And of course, and rightfully so, a jury found him guilty of first-degree murder for shooting that beautiful young woman there, Brooklyn Sims, only 18 years old, while she was working at the Home Depot.
He did take the stand in his own defense, and he testified at trial. He told the jury that he felt hurt and betrayed and mad when Sims turned his back on him after he confronted her about this positive STD test results.
So what did he have to say to himself after he was convicted?
Sentencing hearing.
Yeah, at the sentencing hearing, he did address the judge. Let's watch.
I would like to say that guilty verdict. The charge carries a mandatory life.
So I would like the family to know that anything I say is from the bottom of my heart, that I seek sympathy, that I seek sorry. I would like to apologize to the family, to Miss Bernice, and say I'm sorry. I can't ask for forgiveness because that's selfish. I can't expect her not to hate me because the roles are reversed. Anybody in different shoes feel different ways. If she can't forgive me, I completely understand more than anything. I just want her to know that through our past relationship, through things that have happened, I'm grateful to still have had her in my life, and things that she's done for me have not went without consideration in my heart. I think about Brooklyn every night. Every night before I go to sleep, I pray. I pray for Casey. I pray for Brooklyn. I have regret is an understatement for this. If I could reverse the roles, I would take Brooklyn's place. I had to live with this decision for the rest of my life, and I accept that. I just hate the fact that my family has to go through this. My family also has to go through this, but I made this decision.
Anything further from the defense?
Nothing further.
Judge, I know based on the jury's verdict, the court had one appropriate sentence. I think the court heard the evidence in the case. Judge, it was pretty senseless, it's unnecessary. It took a toll of emotional and domestic violence. And I think Ms. Tim's mother said at the test today that the greatest loser in this whole situation is his son, or his daughter, Casey. She lost that day her father, her mother, and potentially her grandmother. And I know the law requires a life sentence here, and I think the life sentence is appropriate. Obviously, in the state of Florida, there is no parole. That's it, Judge.
Mr. Watson.
Mr. AD is in custody 132 days.
To avoid a pointless appellate issue, is the state seeking an dodge cost of prosecution that's required by the law?
Yes, sir.
All right, so here to discuss still with us, Josh Shipper and Jack Rice. Okay, the defendant tried to apologize. What'd you make?
Yeah, I felt it, right? I mean,
I didn't
he
feel it.
regrets.
Trial. There's no offer of any kind. And what you're really trying to do is take the time to stretch out what happened and explain.
Premeditated murder is literally laid out. It's rare to have such a track record of what your thoughts were, what someone's thoughts were, what they intended to do, the acts they took to do it, and the culmination of it. It's rare that a premeditated murder is literally laid out right in front of the jury. This was the textbook definition of a premeditated murder. Because you got mad and blamed her for something that, in disgusting irony, wasn't even her fault. And had you taken any time to think about it, you would have found that out. But instead, you did what you did. Came over here with one purpose, and you fulfilled that purpose. Traumatizing everybody in that store who had to see it, hear it, run from it. People got hurt. The jury found that you weren't responsible for an intentional battery on two of those people, whether they were hurt from fragments or from getting run out of the store. None of that happens if it's not for you. And that's the minimum part of it. trauma that these people are going to live with, having had dealt with that, having to deal with that for the rest of their lives with noises, with crowds. But the evidence pretty conclusively pointed out you unloaded that gun until it jammed. And you was fired at least, I believe there were, by the testimony was there were 3 more casings or 3 more bullets in the gun, plus another one by the side of the road. 7 shots. And he would have kept going, 2 in the back of the head. And just cold blood. In broad daylight in the middle of a store with coworkers, with customers. The terror that you inflicted on everybody that was around is unthinkable. And unfortunately, that by your decision, then you've had so much time to think about it. You chose not just to end her life, but to throw yours away. To throw away the life that your daughter would have known. Because she's not going to get to know you very well from prison. I hope that she's able to have some relationship with you if that's what her caretakers want. But you forfeited your role in her life. And the tidal wave effect of what you did will reverberate with all these people for the rest of their lives. And with you as well. The jury, having found you guilty of first-degree murder, adjudicate you guilty of that, send you to life in prison, credit for 132 days. 518 in court costs, 150 public defender application and fee. Is there anything else the state believes on the defense? The financial obligations will be reduced to judgment lien. We have 30 days to appeal. We cannot approve an attorney with law.
Yeah, there was life in prison, and as the judge said, lives thrown away. Not only her life, his daughter's life is now without a father and a mother. It's just horrible. Final thoughts here. Josh Schiffer, Jack Rice. Jack first.
I try to imagine the negotiations that were taking place underneath this, because why is it that this case goes to trial? Contemplate what we have, where this young man immediately says, I did it. And let me tell you how I did it. And then he comes in and testifies in this case. That tells you there was essentially no offer to negotiate a plea. Now, if I'm going to be the cynic and the criminal defense attorney, I would also argue this. What is the motivating factor, or why would there ever be a motivating factor to sit down and talk to the police in the first place and tell them what happened simply because you want to bare your soul if there's no way back from that space? He's going to serve life in prison, and yet he was the one who acknowledged what he did, stupid as it was, horrible as it was, and then came in and told the jury or the judge everything else. He said everything.
Is the entire dynamic.
Thank you. So we have our 2 trials, right? Everybody's in jury selection this morning. Unfortunately, they're not letting us see the jury selection. Sometimes I like seeing jury selection, and then it's like other times I be wanting to hear what questions they ask the jurors, but we're not getting that with this, with either one of these trials, at least not that I can see. So I'm not sure. I know that both of them are kind of, I guess. I can't, what time is it in Florida? All right, I think we 3 hours apart. So in Florida, it's probably, let me see. I'm just going to ask my friend, Google. It's 1:17 p.m. So court probably ends about what, 4:30? 5 o'clock. And we still don't have a feed yet into the courtroom. And I looked at the Rule 22s, and Court TV did file for the Rule 22 for both of these courtrooms. I think I'm unmuted at this time, Rachel. You may be a little bit behind us. Hey, Moki. So right? So it definitely looks like that's where we're at in regards to our trial coverage today. I think we kind of updated on everything as far as where we're at, what information we have out there. So we're just waiting for opening statements for our dismembered wife trial and our mama retrial in regards to convincing her son to unalive his baby mama. So I'll ask, like, and I don't know if y'all want me. Do y'all want to stay on and see if any of these opening statements will happen? Do y'all want me to kind of stop the stream and just put out another alert when opening statements for either one is uploaded and putting us into the courtroom? Because I don't know, they are in two different. One is in Georgia and then the other one is in Florida. So I'm not sure if how late they'll allow court to go. But I do know it's the afternoon. I don't know if they'll try doing them after lunch. I don't know if the jury has been selected. There's nothing really updating like minute by minute on here. Let me do this. Y'all know, because y'all know I know how to make polls and stuff now, right? So I just sent out another poll, and if we don't stay online, what I'll do is I'll keep checking to see if either courtroom seats the jury today and does the opening statements. Yeah, because it doesn't take anything for me to actually put it back out there. Hey, D Wood, 513. Welcome, welcome, welcome. Hey, Jason. You said it's my call. What time is your nap time, OnlyFans? Hey, Aaron, welcome. Yeah, because I'm kind of down for either or. It don't make me no difference. I don't know what we can do. I mean, we can find something to do. Okay. That we can always find, right? You said 5 p.m. Eastern. Oh, that's what time you're not? Okay. Okay, so I got you for another couple hours. Y'all want to do some DB? Okay. You said I love watching a good movie. I kind of figured that's why your name was Film Freak. Okay, let me we can always go to our boy. I tell you that. He never fails us. This guy's hilarious.
The case United States versus Cotton, 535.
Mr. Brooks, if you have a motion, you need to put it in writing and then I will address it. I'm not going to deal with any oral motions right now.
Okay, so just let's watch another trial. When you say let's watch another trial, is there another? I mean, I'm gonna replay. I'm gonna put up the feed from where we last left off with our Daryl Brooks replay. He's always entertainment, right? And in the background, I'm gonna be trying to see if I can figure out which one of these courtrooms gonna sit. Okay, you say it takes 1 to 2 days, so opening statements won't likely start to the afternoon on Wednesday. Okay, thanks. Okay, all right, just be nice. See you when you get back. So this is for all the people that when we were watching the Daryl Brooks replay, I'm just kind of like putting us back into that replay right where we left off. And that was on day 4, part 2 in the afternoon. In the meantime, I will check and see in regards to jury selection to see if one of these juries will be seated for us today. Yeah, and I think that'll be our plan for right now. And if anything changes, then we'll change it. We'll we just go with the flow as we go along. We just go with the flow of things. It is what it is. Okay, guys.
Now, so if you're asking me to reconsider something, you need to follow the proper procedure.
What is the proper procedure, Your Honor?
I've told you repeatedly what a motion is. So if it's a reconsideration, 806.07 is the statute I would direct your attention to.
It's not a reconsideration. It's just bringing up the subject matter jurisdiction again. Which
Sir, I've already dealt with this repeatedly. So any further times you want me to address it, you need to put it in writing for the court to consider a proper motion with the relief that you're requesting, the legal basis, and the facts upon which you are relying.
I have that here, Your Honor.
not just simply a case. I want a motion.
I've put in several motions that have yet to be
Sir,
answered.
I've already addressed them. The jury's on its way out. I'm not going to delay the start of this cross-examination for this argument yet again.
It's
I've
not an
already
argument.
addressed it. The fact that it's the afternoon doesn't mean I need to address it again. Jury's coming out.
It's going to continue to be brought up. It's going to continue to be brought up, Your Honor. It hasn't been proven that you have jurisdiction, that this court has jurisdiction. I think it's relevant. Subject matter jurisdiction can't be forfeited or waived. You know that. By not answering, Your Honor.
Please, the jury's coming out.
By not answering, Your Honor, you are agreeing to a tactic agreement. Is that a judicial determination that you don't have to answer? I'll take that as a yes.
Thank you, everyone. Please be seated. All right, Mr. Brooks, you may question the witness if you have any questions for her.
I don't consent to being called that name, as I stated before. I will note that, like that
The
noted for the
defendant can
record.
question the witness then.
Is that noted for the record, Your Honor?
Ask your questions, please.
Is it noted for the record, Your Honor? As you testified to earlier, you were present at the Christmas parade on November 21st of 2021. Would that be fair to say?
Yes.
Do you remember about how long you intended to be at the parade?
Just until we finished the route.
It was a few exhibits that you stated on record that you weren't familiar with seeing. Would that be fair to say?
Once clarified, I did say that I remembered seeing them.
So you saw those videos before today?
Yes,
About how many times do you recall seeing them before today?
just once.
Do you recall who showed them to you?
Yes.
You stated for the record and for the jury.
Can you repeat that?
Can you state who showed you the videos for the record and for the jury?
Yeah, the state.
And who would you be referring to when you say the state?
The three seated next to you.
Are you referring to the opposite table next to me?
Yes.
Let the record reflect that. She identified the three prosecutors sitting at the prosecution table.
No objection.
The record will so reflect.
Do you recall knowing if you would possibly be called to testify?
Yes.
Were you expecting to testify?
Yes, I got a letter in the mail.
Do you recall if that letter was a subpoena?
Yes, it was a subpoena.
You frequently referred to the vehicle as the car. Do you recall those statements?
Yes.
So for clarification, what type of vehicle did you see that day? Was it a car?
It was a Ford SUV.
And how were you able to determine the make and model of the vehicle?
Objection. The witness did not describe the model.
Grounds.
Overruled. She may answer the question.
So when I first saw it, I made a point to figure out what car it was, not the license plate. and I knew it was either that an Escape or a Mercury. And then as the vehicle got closer to me, I saw the Ford emblem. That's how I knew it was a Ford.
And during those determinations of the make and model of the vehicle, did you catch a description of the driver?
No, I did not.
Any reason why you would be more focused on the make and model of the vehicle instead of who was driving the vehicle?
I can't tell you why. I just made sure I knew what the vehicle was.
And you didn't try to see if you can spot a license plate at any time?
It all happened way too fast.
So would it be fair to say that it happened fast enough for you to not be able to make out the model and make of the vehicle?
No, I knew exactly what it was.
But not exactly who was driving the vehicle?
No, I did not look who was driving it, just the make.
You stated that you observed some girls from your dance team in the hospital. Would that be fair to say?
Yes.
And you stated that a few of them were laying on the ground?
Yes.
Any idea why they would be laying on the ground in the hospital?
Because there was so many people, there wasn't enough room. So people were standing, sitting, and laying on the ground because the rooms were overflowed.
Were they being attended to at that time?
Nope, because there was too many people.
Did you recall feeling like maybe they should have been attended to, seeing as how they may have been seriously injured?
The nurses were attending to who needed it immediately. The nurses were doing the best they could.
So it would be fair to say that the girls that you observed on the ground weren't of immediate concern to the nurses at that time?
At that time, they weren't.
Were you injured in any way during this incident?
I was not.
And you testified earlier to the approximate speed of the vehicle. Do you recall what your answer was?
Yeah, about 55 miles per hour.
And how were you able to come to that determination?
Because I've drove for a couple years now, and that's just the number that came to my head. Because when I drive, I know what 55 feels like, and I know what 25 feels like, and that was just my best guess.
So it would be fair to say that you were making an assumption. You didn't know for sure.
Nope. Yeah, that was just my best guess.
You made a reference to a young woman by the name of Sam. Would that be fair to say?
Yes.
And what relation do you have to Sam? Is she just part of the dance group or close friend or?
Yeah, she's part of the dance group, but I became super close with her ever since I started working there.
Do you recall seeing her struck by the vehicle?
No.
Do you remember where she was at the time that you saw the vehicle pass you?
Yes, she was on the front left side. If you're looking towards the truck that was in our group, she was on the left side in front, first row.
Would it be fair to say that from that angle that you would be able to see her if she was struck?
I was turned the other way. She was behind my back.
So you don't know for sure where she was at when the vehicle passed you?
I do. She was in her formation that I had put her in.
Do you know if anyone was standing there or in that position with her at that time?
She has her own spot, and there was girls behind her and next to her, but she would have been the only dancer in her spot.
So it would have been people in her general area, but not directly next to her.
Yeah, they have space in between all of them.
Do you remember what you did immediately after the vehicle passed you?
Yep, I ran to Alice and I picked her up immediately.
In regards to your dance team, did you observe anyone struck?
I just remember seeing bodies in the air, but I can't say I remember seeing a vehicle hit them. I remember seeing bodies in the air and on the ground.
So at that point, it would be fair to say that you didn't know if the people that were on the ground or in the air or whatnot were in fact struck by a vehicle.
Well, I did know it was the vehicle because I turned around and I saw the vehicle coming towards them. And then I think I blacked out until they actually were in the air and on the ground.
By blacked out, what do you mean by that? State that, what that means for the jury and for the record.
So I can't see anything, but I can hear it. So when I say blackout, I mean I can't visualize it, but I can hear it happening.
Was that the first time that you ever had a blackout?
Yeah,
So it's never happened before that day?
never.
Any idea what caused it on that occasion?
No. Stress, shock.
And you stated that you got into a ambulance and with someone who was struck and then left the parade at that point?
A squad car, yes.
Oh, I'm sorry, a squad. You left at that point.
Yeah.
Do you recall about what time that was?
No.
Do you recall how long you were with the person being transported at that time?
No, I wasn't worried about time.
Do you recall if anyone was walking directly next to you at the time of the incident?
I was walking next to the girls on my team that got struck.
Do you recall walking next to Sam or Sam walking next to you?
No, she was behind me.
Do you recall making the statement that, and this is, I'm guessing, in a summary report given to Detective Schwartz? Do you recall being interviewed by Detective Schwartz?
Mm-hmm. Yes.
Do you recall making the statement that Samantha was walking next to you?
No, I don't recall that.
Do you recall making a statement that you did not have enough time to tell Sam to move?
Yes.
And this was the same Sam that you just testified that you did not see struck, correct?
Yeah. Yes, I didn't see her hit.
So it'd be fair to say that you made the statement that you didn't have enough time to tell her to move, but didn't actually see what happened to her.
Because she was on the same side as me, and that's why I was saying I didn't have enough time to tell her to move, but I wasn't next to her.
Any idea what may have stopped you from being able to see what happened?
Because I blacked out.
At the point that you blacked out, at that point, you didn't see anyone struck. Would that be fair to say?
I don't remember exactly the vehicle hitting, but I just remember bodies flying. I think I kind of try to block it out.
Do you recall making a statement that everything happened so fast,
Yes.
but not fast enough for you to identify the vehicle?
Nope. I remember exactly what the vehicle was.
Do you recall if the vehicle had any damage at that point?
I was only paying attention to what kind of make it was because I could see the body of it was an SUV. And like I said, I thought it was either the make with the Mercury or a Ford. And so I was just paying attention to the emblem when the grill got closer and I saw it was a Ford. I wasn't looking for any damage.
About how close would you estimate the vehicle came to you?
I don't know.
Did it get close to you?
I don't know. I blacked out.
Do you remember what side of the road you were on when you blacked out?
Yeah, I was on, if you are looking at the truck, I was on the left side. So if you're walking in the parade, I was on the left side. But I had turned around, and so I was on the right side because I was looking at the vehicle.
So at what point did your memory go fuzzy?
So I turned around and I saw a car or an SUV, and I told myself, "You're crazy, you don't see that." And then all of a sudden, I don't remember anything. I can hear it, and then after, I remember seeing the bodies. So I would say I blacked out from when I saw the vehicle to after it passed.
Any idea how long that may have been, roughly, if you recall?
A second.
So pretty much like the snap of a finger.
Yeah, because it went by so fast.
And from your recollection, that was quick enough for you to miss anybody being struck.
I blacked out, so I didn't see them physically get hit.
Outside of Detective Schwartz, were you interviewed by any other law enforcement?
No, I only gave that statement, and that was it.
What about at the hospital? Were you interviewed at the hospital?
No, I was not.
Did you call yourself to make a report about what you saw that evening?
No, I went and gave the statement right after I left the hospital, and that was it.
Did you do any follow-up to see if your report was received by anyone in law enforcement?
No.
Did anybody from law enforcement contact you about the statement that you gave?
No.
Do you recall at any time reading or seeing a complaint in this matter?
No.
Do you recall at any time filing any claim in this matter?
No. Are you saying with the police department?
Yes, with the police.
Yeah, no, I just gave a statement and that was it.
Would you consider yourself a party to this matter?
Objection.
Grounds.
Sustained. Unroll this man.
Do you recall if you were contacted by the plaintiff in this matter?
Objection.
Grounds.
Relevance.
Grounds.
Overruled, she may answer.
Can you say who the plaintiff is?
I'm asking you, are you aware of the plaintiff? Were you contacted by the plaintiff at any time?
I don't know what the plaintiff is.
The plaintiff would be whoever is bringing the claim for the charges in the matter.
So not, then yeah.
Objection.
Yeah, what, you were contacted by the plaintiff?
Objection.
She answered yes. I'll answer grounds.
An objection, hold on.
Objection. Move to strike
Grounds.
legal analysis.
Grounds.
And the defendant has testified.
I'll sustain the objection. I'll grant the request to strike the question and the answer for the reasons given by the state. You may rephrase if you'd like.
Who were you contacted about testifying?
The state.
And that, I'm assuming the state of Wisconsin, correct?
I just know them as the state, right there.
Right there, as in referring to the prosecution table?
Correct.
Let the record show that she identified the state as the three attorneys at the prosecution table.
No objection.
Record will still reflect.
And do you recall having a conversation with the state?
Yes.
Would it be fair to say that you would identify the state as the plaintiff in this matter?
Objection. Relevance.
Grounds.
Sustained.
Have you ever had any interactions with the plaintiff in this matter?
Objection.
Grounds.
Relevance.
Sustained.
Do you see the plaintiff in the courtroom today?
Same objection.
Grounds.
Sustained.
Do you even know if there's a plaintiff?
Same objection.
Grounds.
Sustained.
So as far as you know, in your opinion, who would you say is the plaintiff in this matter?
Objection.
Grounds.
Sustained.
Were you present at the parade with any family that day?
No.
Just 1 second. And when you visited the hospital, how did you learn of the injuries to any of your dance team partners?
Which hospital are you referring to?
I only heard you say Memorial. You might have said two. I think you said Children's one time too. Would that be fair to say?
Yeah, that's correct.
I guess I would be referring to Memorial.
So the only injury, well, not even injury, I only knew Julia had something wrong with her brain at the time because they saw spinal fluid coming out of her nose.
And were you told that directly from a doctor?
I heard them freaking out and rushing her to a CT scan because I was right next to her, helping them as she seized and vomited.
So you overheard from the nurses what the diagnosis was?
Yes.
What about for Sam?
Are you referring to the night of?
Yes, when I'm guessing you saw her at some point that night.
I did not see her that night.
Did you see her at any point?
I did. I was there at the hospital the first day she was able to have a visitor.
And were you told directly by medical professionals at that time that you were able to see her of any possible injuries?
I wasn't told by them. She actually called me.
Can I strike that answer for hearsay, Your Honor?
No, you asked the question.
But the answer was hearsay.
But you asked the question.
In the days after the incident, did you have quite a few interactions with the dance team?
Yeah, we tried to keep ourselves busy and we did a lot of things together.
Did you attend any visuals or any memorials or anything like that?
Yes, I did.
Would you stay for the record and for the jury? How many?
I believe it was on Monday. I went to that vigil.
And that would be the only one that you attended?
Yeah, that was the only one they had.
Were you aware of things set up financially for the victims?
Can you repeat that?
Were you aware of any for example, like GoFundMe's or donations or anything for the victims? Were you aware of anything like that going on in the days after the incident?
Objection.
Grounds.
Relevance.
Grounds.
Sustained.
You yourself donate to any causes associated with the incident?
I did not.
Are you still currently a member of the dance team?
Can you tell me which one you're referring to?
What is it, stream dance team?
Yeah, I am not. I do not work there anymore.
And was that decision made by the incident or was it just a personal decision?
Objection.
Grounds.
Sustained.
You testified earlier to having the blackout and that being the first time that happened. Would that be fair to say?
Yes.
Have you had any blackouts anytime since that day?
No.
First and only time would be that day.
Correct.
No further questions.
Yes, thank you. Ms. Kajewski, with respect to that blackout, you testified that you don't have a visual memory of the SUV actually striking any girls that day. Is that right?
Correct.
You testified, however, that you remember what it sounded like.
Mm-hmm.
Describe that.
Yes, sorry. Yes, so it sounded like those big orange construction cones just being hit. That's what I remember it as.
You do have a visual memory of the immediate aftermath of the strike?
I do.
And what is that memory?
Objection. Hearsay.
You may answer. It's overruled.
Just pure chaos, shoes everywhere, palms everywhere, bodies, people screaming, running around, just chaos.
When asked on cross-examination what caused your blackout, you said stress and shock. You remember giving that testimony?
Yes.
At any time in your life before November 21st of 2021, had you ever witnessed an SUV drive through a group of young women?
Objection.
No.
Hearsay.
Overruled.
Objection. Relevancy.
Overruled. You may answer.
No.
What about any time since November 21st, 2021?
Objection. Relevancy.
Overruled.
No.
That's all we have. Thank you.
Thank you. You may step down. She may.
Thank you. Call Jamie Sutton.
good afternoon. Ms. Sutton, if you would please make your way to the witness stand, which is to my right up one riser. When you get there, please remain standing, raise your right hand, and my clerk Teresa, who's on my left, will swear you in. She's right here. Oh, that's okay.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Thank you. Please have a seat. The first thing I would like you to do is to state your first and last names for the record and then spell each.
First name, Jamie Sutton, Jaimie. Last name, Sutton, Sutton.
Thank you. Go ahead, your witness.
Thank you. Ms. Sutton, how old are you?
I'm 23.
Do you have an affiliate, or have you ever had an affiliation with the Extreme Dance Group here in Waukesha?
Yes, I worked there last year.
How long did you work for Extreme?
From May of 2021 to April of 2022.
What was your role with the organization?
I was a coach for the junior team.
What's the approximate age range of the junior team?
About 8 to 11 years old.
How many people were part of that group, the junior group?
10.
And did you participate with your dance team in the Waukesha Christmas Parade on November 21st of last year?
Yes.
You yourself were actually present for the parade?
Yes.
Did you attend as spectators or did you march in the parade?
I marched in the parade.
With your girls?
Yes.
Do you remember approaching the 5 Points intersection?
Yes.
Do you remember what happened at that intersection?
A car drove along my left side.
I'm going to ask to put up for the jury exhibit number 15, which has previously been received and published.
Go ahead.
Okay, do you see the screen in front of you?
Yes.
You see a group of names in a green box at the bottom of which is titled Waukesha Extreme Dance.
Yes.
Are you familiar with the names in that list? You can take a few moments to read through it if you'd like.
Yes.
And the black line connecting that box to a star, you see that?
Yes.
Does that star accurately represent the approximate location where you and your girls were when the car came through your group?
Yes.
Okay. I'm going to ask that we display exhibit 32 and publish it. It's previously been received and admitted. Excuse me, published.
Go ahead.
This is 1 minute and 23. We're not going to play the whole thing. Ms. Sutton, what I'd like to do is to play this from the beginning, and then at a certain point, I'll pause it, and I'm going to ask you to see if you see yourself on the video, okay?
Okay.
So we're just going to take a look at this from the beginning. Pause, please. We've paused at the 43-second mark. Do you see yourself on the screen?
Yes.
So that's a touch screen in front of you. Can you use your finger and circle yourself for us? Okay, so what's on your head?
I have a gray hat on.
Gotcha. Okay, we can clear that, please. We'll continue watching from that point. Pause. We've paused at the 57-second mark. Based on the video that we've seen so far in this exhibit, did it appear to you as though the girls were maintaining their position in the group?
Yes.
Okay. Could we display for the witness exhibit number 33 and publish this as well, please? It's previously been admitted and published.
Go ahead.
I would like you, Ms. Sutton, to please take a few minutes or moments and look at this exhibit, read all the names. Let me know when you're done.
Okay.
The boxes with names in them, are they accurately represented in this diagram based on where they were in the formation in real life?
Yes.
Okay. I now would like to play for the witness only, exhibit number 36, please.
Go ahead.
So we've played about 11 seconds for you there. Do you recognize that video?
Yes.
Have you seen it before?
Yes.
What does it show?
It shows a car hitting some of our girls.
Is that video an accurate depiction of how the events unfolded that day?
Yes.
I'd move exhibit 36 into evidence and ask for permission to publish.
Exhibit 36 is received. Permission to publish is granted. May I please have the total length of the video?
This is 29 seconds. We're going to play from the beginning and we're going to turn the audio on.
Your Honor, is the video playing at the right speed?
My understanding is it will be.
We'll double check for Mr. Brooks. Can we make sure that we've got it at 100%? Yep.
It just wasn't turned up. So that means when it was just showed, it wasn't playing at the right speed.
I think I can just very simply clarify. To adjust the speed, you have to change it to see what it's set at. So it was at 100% and it is now back at 100%.
I object to that for the record. Clearly wasn't at the right speed.
The record reflects the statement made by Attorney Wichow regarding the speed, and the court accepts that. Go ahead.
And the objection.
Okay, I'd like to go back to the beginning of that, please. We're going to pause, please. We're going to slow that down, Ms. Sutton. And I'd like you, at a certain point, we're going to pause. And if possible, if you can, I'd like you to identify some people in the frame for us, okay?
Yes.
All right, so we're going to play from the beginning at, can we reduce it, please, to 40%? And turn the sound off. Okay, we'll play from the beginning. Pause. Paused at 12 seconds. How many people do you see laying on the ground, Ms. Sutton?
I see one person laying on the ground in this frame.
And could you circle them for us? Who is that?
That is Vivian
What's her last name?
Ural.
I'd ask to preserve the annotation, mark it as Exhibit 36A, and enter it into the evidence, please.
The annotation will be captured. It will be marked as 36A. It is received.
Could we please remove the annotation? And can we go frame by frame for a few frames here? Pause. So we've stopped at 12-second timestamp. At the moment that the SUV first made contact with your group, where were you in relation to the rest of the group?
I was towards the back right side of the group.
Right,
looking
as
under
in
us.
standing in the road and looking down the parade route?
Yes.
Okay. Based on your position in the road and your memory from that day, are you able to identify anybody else who's depicted in the video at this point?
I believe that's Olivia Stover in the left.
And what color is her hair?
Brown.
Could you please circle Olivia for us? And as to preserve that annotation and mark it as Exhibit 36B and to enter it into evidence, please.
Face.
Your objections noted. 36B is received, and the annotation will be captured and preserved for the record.
We can take that down, please. Ms. Sutton, can you walk us through your memory of what happened as the SUV began to go through your group?
Yes, I was in the back right with some of our younger teams and was helping them get in their formation. And I heard some yelling behind me, some screaming, and I looked over my left shoulder. And just as I looked over my left shoulder, there was a red car that drove through. By the time I looked, it was already hitting our girls.
What happened next?
Girls that were not injured started to run over to the sidewalk. So I started to gather them all in one area.
What happened next?
I tried to reunite those that I could with their parents. Those that I couldn't, I took with me, and I heard there was an active shooter. So we went into Chef Pam's kitchen and hid out there until we were told it was all clear to go to our cars.
Chef Pam's Kitchen is a business, a storefront on Main Street?
Yes.
Okay. What happened next?
After that, I went to my car, went to the hospital, and did my police statements.
In the immediate aftermath after the SUV came through your group, did you at any point see a person named Charlotte Urell?
Not that day.
Okay. You know who Charlotte Urell is?
Yes.
Can you explain for us her relationship to the extreme dance group?
Overruled. You may answer.
She is the older sister of two of the Waukesha extreme dancers.
Was she with your group in the parade?
Yes, she was handing out candy.
Okay. And you said you didn't see Charlotte that day. When did you next see her?
Well, I saw her that day before the parade started, but I didn't see her in the aftermath.
Okay. When did you see her after the SUV went through the group? When's the next time you saw Charlotte Urell?
Weeks later at the dance studio.
Okay. And did you make any observations of Charlotte at that time?
She was on crutches.
Do you know why she was on crutches?
She was hit by the car that drove through.
During the parade?
Yes.
The red SUV we saw in the videos you watched?
Yes.
What about Grayson Urel? Do you know who that is?
Yes.
Who's that?
He is the younger brother of two of the Waukesha extreme dancers.
Did you see Grayson Urel marching with your group during the Christmas parade
Yes.
before the SUV came through the group?
Yes.
Did you see Grayson Urel at any point after the SUV came through?
Not that day.
When is the next time after the SUV came through your group that you saw Grayson?
Weeks later when he was discharged from the hospital after being hit from the red SUV.
Okay. And what personal observations did you make of Grayson at that time?
He had a large cast on his arm. I believe he might have been in a wheelchair or crutches.
Can you describe for us the uniform that your girls were wearing that day?
They were wearing black leggings, black Waukesha extreme jackets, white Santa hats with light up headbands attached to them, white light up gloves, and white pom-poms.
Could we please display for the witness only exhibit number 102? 102. Ms. Sutton,
Okay.
just let me know when you see the screen, okay? Okay. What are we looking at here?
This is a red SUV that is smashed up. There's a white light up headband on what used to be the side mirror.
Do you recognize that white light up headband?
Yes.
What is it?
Objection, hearsay.
Overruled. You may answer.
That is one of the headbands that was over our girls' white Santa hats.
Is this photo an accurate depiction of how that headband looked the day of the parade?
Yes.
Before, obviously it's not on anybody's head right now.
Yes.
Okay. I move exhibit 102 into evidence and ask for permission to publish.
The court's going to withhold receiving exhibit 102 until further foundation can be laid. So permission to publish is denied at this point.
That's all I have. Thank you.
All right. Any questions for this witness?
Yeah. Do you recall what time you arrived at the parade that evening?
The parade started at 4. I believe I was there around 3:30.
Did you come with anybody or?
I came with Alyssa.
Would it be fair to say that you guys are pretty close?
Yes.
Do you recall giving a statement to Detective Schwartz?
I gave a statement to a deputy. I don't know their name.
Do you recall at what time that was roughly after the incident?
It was around 6:30 that night.
Do you remember where you were when you gave the statement?
It was at the transit center, the Waukesha Transit Center.
And when did you first notice a vehicle approaching?
I heard screaming and yelling behind me, and that was when I looked over my left shoulder.
Do you recall how close the vehicle was to you at the time where you looked over your left shoulder?
It was on the left side, and I was on the far right. So it wasn't very close to me.
Were you able to identify any driver of the vehicle?
No.
Would it be fair to say that you referred to it, the vehicle, numerous times as car?
Yes.
Would it also be fair to say that you then identified it as an SUV?
Yes.
So what exactly did you see? What type of vehicle did you actually see, a SUV or a car?
It was an SUV.
Any reason why you would refer to it as car?
I refer to all cars as just cars, no matter what they are. If it's a truck, it's still a car.
Would it be fair to say that certain vehicles look different than others?
Absolutely.
At what point do you recall hearing that there may have been an active shooter?
Could you repeat that question?
At what point do you recall hearing that there may be an active shooter?
When I was gathering the girls who hadn't been hit, a man came up to me and said that there was an active shooter amongst all of that.
Do you recall if that was somebody marching in a parade or a spectator, or
I'm not sure.
were they any law enforcement?
No.
Did you hear any shots?
No.
And where did you go from there after you were informed that there may be an active shooter?
I went into Chef Pam's kitchen.
Did you go in there alone, or?
No, people were piling in there, and I had several girls with me, several dancers with me.
You were shown a few videos. Do you recall seeing those before today?
Yes.
How many times have you seen them before today?
At least 10 times.
So pretty frequently you've seen them.
Yes.
Would it be fair to say that you saw those numerous times to maybe bring back something you couldn't recall?
Yes.
You state for the record and for the jury who showed you these videos multiple times?
They were sent to me.
So that would be, were they sent via email or?
Over text message.
Text messages.
Yeah.
And can you state for the record and for the jury who the text messages were sent from?
Alyssa.
So they weren't sent by any law enforcement or?
No.
To the best of your knowledge, can you recall how Alyssa was able to obtain the videos that you saw today?
I'm not sure.
So she never mentioned that to you in any way at any time?
No.
Were you able to identify the driver?
No.
Were you able to identify a license plate number?
No.
Were you injured during the incident in any way?
No.
Did you go to the hospital after the event?
Yes.
Were you transported there, or did you drive there yourself, or?
My fiance drove me there.
Do you recall how long you stayed at the hospital?
Not long. I was told just to go give a police statement.
So it would be fair to say that you went to the hospital strictly for the police statement
I went to
purposes?
the hospital to see if the girls that I had unaccounted for were at the hospital.
And were you able to gain the information that you were seeking?
Yes.
So that would explain the brief stay at the hospital?
Yes.
Did you learn any additional information at that point?
Nope.
Do you recall in the statement that you gave to Detective Schwartz that you observed people running towards the sidewalk?
Yes.
Did you see anyone on the sidewalk struck by the vehicle?
No.
Do you recall stating that you were waiting inside of a building for what seemed like a long time?
Yes.
And what would you estimate time-wise, what time frame that would be?
Probably.
Just object here and ask for clarification about what building we're talking about.
So stay just to the form of the question, please rephrase.
Well, from the report, it just says they needed to seek shelter inside of a building, so it doesn't say the name of the building in the report. I guess that's why I didn't refer to a specific name of the building.
Just ask your question, Mr. Brooks. Please rephrase.
How long would you estimate you seek shelter?
Probably around an hour.
And did you immediately leave from that point?
I made sure all of my girls were reunited with their parents and family members. And once they were all reunited, then I left.
Do you recall giving a written statement?
Yes.
Do you recall who you gave the written statement to?
No.
Do you recall in your written statement saying that it seemed as if something was wrong with the vehicle?
Yes.
And what would you, from your recollection, what would you say was wrong with the vehicle?
It was going very fast. I thought maybe there was brake failure happening because it was going so fast.
And what made you come to that conclusion?
Because there was a car driving through a parade instead of slowly rolling through like the other vehicles.
So it'd be fair to say your initial thought was something was wrong with the vehicle.
Yes.
Did you see any smoking from the vehicle, any damage to the vehicle at that point?
No.
After you had been waiting in the building for a while, who came and informed you guys that it was okay to leave at that point?
It was police that came and told us we were clear to go.
Was it one officer, a couple
Just
of
one.
them? Two of them?
Just one.
You don't recall their names by chance?
No.
At that point, did you ask the police officers for any information about the active shooter?
No.
About what time would you estimate that you left the parade?
After I got the all clear,
Do you recall what time that was?
I do not recall.
Do you recall if the vehicle had any tinted windows?
I do not recall.
Were you close enough to the vehicle to make out the make and model of the vehicle?
No.
Do you recall any windows being down or anything like that?
No.
Do you recall anything being tossed from the vehicle, falling out of the vehicle?
No.
So it's just pretty much just moving straight.
Yes.
About how long would you approximate you watch the travel of the vehicle after it had passed you?
I didn't watch the vehicle after it went past me. I was looking at the dancers on the ground.
So it would be fair to say that once the vehicle passed you, you couldn't see if it struck anyone else at that point.
Correct.
No further questions.
Any redirect?
No, Your Honor, thank you.
Thank you. You may step down. She may. Please call your next witness.
State calls Detective Mike Carpenter.
Good afternoon, Detective. If you would please make your way to the witness stand, which is to my right. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, who's on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat. First thing I will have you do is to state your first and last names for the record and spell each.
Michael Carpenter, first name spelled Michael, last name spelled Carpenter.
Thank you. Go ahead.
Thank you. Detective, what do you do for a living?
I'm a detective with the City of Waukesha Police Department.
How long have you been a detective?
I've been a detective for approximately 12 years.
How long total in service with the Waukesha Police Department?
Approximately 20 years.
Is that your first job, Waukesha Police Department?
I worked a brief stint for about 6 months each at the Town of Brookfield Police Department part-time and the Town of Merton Lake Patrol part-time before moving on to the City of Waukesha.
What is your current assignment as a detective?
I'm in the computer forensics unit.
What type of things do you do in that unit?
Analyze digital data, digital video recorders, cell phones, regular computers, pretty much anything that can hold digital media.
Okay. Did you conduct a speed analysis in this case?
Yes, I did.
Can you walk us through when you set out to conduct a speed analysis? First of all, what is it and how do you go about conducting that analysis?
Basically, throughout reviewing video for this incident, we wanted to determine if there was a way to get an accurate speed from the red SUV. I've been through some training, certified as an input ACE examiner. That's a software we use. And we determined that there were cameras that existed along the parade route on West Main Street that may have held useful information. Specifically, we were looking for surveillance video that was still in its native proprietary format that would still hold that metadata that would let us conduct a speed analysis. I did locate Bosco Social Club, which is a bar located at 260 West Main Street in the City of Waukesha that had a proprietary format that I believe that let us do that analysis.
How many cameras were affixed to the Bosco's storefront?
There were two, one on the southwest side of the building and one on the southeast, at least that we used. I believe they also have video inside and towards the rear of the establishment, but we were concerned with the cameras facing West Main Street.
So once you get the surveillance video, what do you do with it?
I viewed the video to determine if it would be suitable. The video was, in my opinion, pretty high quality. I could see the vehicle clearly traveling westbound on West Main Street. So we believe that we'd be able to explore that further and try to conduct the analysis from that.
So what did you do?
The next step was we had to determine what an accurate frame rate was for the camera. Most surveillance systems have what's called a variable frame rate. In defining a frame, basically a video is a series of still images or frames put together to show motion. However, that can vary from frame to frame. That timing may not be exactly the same. We went down to Bosco's and placed a device in front of each camera called a VFR light board that's supplied and calibrated by the company Input Ace. We placed it in front of each camera, and that board's got a series of flashing lights that have timing in them. Recorded a video of that board from each camera, and then returned to my forensic lab and placed that into the Input Ace software, and we were able to calculate the timing more accurately between each frame, so we had a more scientific approach to it.
And what did you do with that information?
Once I had that information, let me back up. Prior to having that information, I had also asked Specialist Plata of our Criminal Evidence Forensics Unit, our traditional forensics, to respond to the area of Bosco's and use the department's, it's called FARO, F-A-R-O, their 3D laser crime scene mapping device. They mapped various points in front of Bosco's, and we were able to basically find the orientation and the position that the eastbound camera was facing. And then once that was done, we could take a screenshot of that 3D scan, which measures, my understanding is millions of points. Once I had that done, I was able to bring that into Input Ace software to begin the overlay process where I could overlay the images on top of each other. So we brought the screenshot of the 3D scan in, brought a partial video in of the red SUV traveling westbound. It began to compare points from the 3D scan and the video and began to plot those points. For instance, a intersecting crack in a sidewalk. If I could see it in the 3D scan, I would plot that point and then match it up in the video. Did that over a number of points, and then that enables us to lay the video identically on top of the 3D scan. Once that was complete, then that's where we started bringing in the light board video to find out the timing, to find out how many milliseconds or seconds passed in this incident. In this particular video, I was concerned with frames 35 through 60 of that vehicle traveling westbound. Once I obtained the timing from the VFR light board, I determined that with the assistance of the software that the average was 0.834 seconds had passed in those 25 frames that that vehicle, or I'm sorry, 26 frames that that vehicle continued westbound. What that does, it then gives me a low end and a high end that I can use for a margin of error. So it said the longest time it would take for the vehicle to travel westbound through those 26 frames would be 0.838 seconds. And the quickest time that it could pass through those 26 frames would be 0.830 seconds. Once I had that information, I was able to completely overlay the video onto the 3D scan, and I could start at frame 35, and it enables me to overlay it within the 3D scanning software, and I was able to drop a small point. The clearest point of reference in this view, as there were people around it and other things in the area, I was able to pick the front passenger's wheel and drop a point directly in the center of that wheel, advance frame by frame until I was at frame 60, drop another point, and then I can use a slider to go back and forth to either have the vehicle present or just the 3D scanning. Once I had just the 3D scanning, then I could take and measure the distance from that first point in frame 35 to the last point in frame 60. And then I was able to calculate that. I was able to input that in with the different measurements of 0.838 seconds and the 0.830. When I did that within the software, it told me that the distance was 12.7477 meters. When I converted that to feet, I believe it was 41.8231 feet. That allowed me to compare that with the fastest that the vehicle could travel and the slowest that the vehicle could travel. And with the margin of error, convert that to feet per second and then miles per hour, which came up with a measurement for those 26 frames of 33.7 to 34.6 miles per hour in those particular frames.
Can we project for the witness and for the jury exhibit number 15, which has previously been received and published?
Go ahead.
Okay, do you recognize the area on the map depicted in exhibit 15?
Yes, it's the 5 Points intersection area of downtown Waukesha.
The screen in front of you is a touch screen. Could you just draw a small little X to depict where the approximate location of Bosco's is?
I believe it's going to be roughly right about here.
So north side of Main Street?
Yes.
Okay. And I don't think we need to save that. We'll just say it's an X between the 5 Points intersection and Gasper Street on Main. So we'll clear that and take that down. And now can we please project for the witness and for the jury exhibit number 31, which I think that's also been received and published. And it has, yep. Okay, you see the screen in front of you?
Yes, I do.
Is this the video from Bosco's that you have been talking about today?
Yes.
Okay. Let's start at about the 10-second timestamp. Now you were talking about 26 frames, I think you said?
Yes.
Okay. Let's slow this down to about 50%, please. And we'll play from this point.
9 seconds.
Sorry, yes, 9 seconds. Pause. We have paused at 16 seconds. So you're basically measuring what? Walk us through the screen here. What are you measuring?
So as soon as the red SUV came into view of the video traveling westbound, once I had a frame where there was no obstruction, I could see the full passenger side tire. That's where I dropped my first point, and then I let the I let the SUV continue westbound until I found another spot where there was no obstruction. Now, when I overlaid it between the 3D software and the video I have here, during this video, there's no foliage on the branches. During the 3D scan, there is foliage, so that blocked a little bit, so I had to stop a little earlier than what I wanted. But I was just basically measuring how far that SUV or that wheel traveled during those frames in that amount of time.
Okay, so you're measuring distance and time.
Yes.
And from that, you're calculating speed.
Yes.
And you've already talked about the different variables that you took into consideration, right?
Yes.
And that resulted in, what's your ultimate conclusion?
33.7 to 34.6 miles per hour.
And the 26 frames that you're talking about, they are in this video?
Yes.
Okay, let's just play from the 16-second mark. Pause. And we stopped at the 17-second mark. So the 26 frames are entirely within that 9 second to 17 seconds.
Yes.
Okay. That's all I have. Thank you.
Thank you. Go ahead, Cross.
Very, very briefly. You stated earlier that in reference to traveling through frames that sometimes you may encounter problems with the estimation. Would that be fair to say?
No, I don't believe that was my testimony.
You testified to at one point or another that sometimes exact timing of speed could be a little inaccurate.
No, I don't believe that properly characterizes.
What were you referring to at that?
I was referring to that digital video recording systems, surveillance systems, they use something that's called variable frame rate. I can't say that every single one does, but almost all of them do. That from frame to frame, it could change by a millisecond, hundreds of milliseconds. To do this the most accurate scientific way possible, that's why we conducted it the way we did with the variable frame rate board.
So there can be sometimes miscalculations. Is that fair to say?
I don't believe so in the way we performed it, no.
Well, I was referring to the process in general, which you just stated that sometimes by milliseconds, hundreds of milliseconds, a millisecond, that sometimes there can be miscalculation.
I'm not sure I'm completely understanding the question. Are you asking in this specific example or just in general?
The process in general.
Somebody conducting an analysis a completely different way, it's possible, but in this analysis from my training experience is the most scientifically possible way we can do it.
And before this occasion, had you used the same method that you used for this occasion?
Yes.
How many times?
I had not used it in a live case yet. This was our first chance to do this, but I done it a number of times in our training examples.
But the first time you've done it in a live case?
Yes.
Can you state for the jury what is the difference between a live case and any other case?
There really is no difference. The training examples are hands-on, and the process we follow through all those examples to establish competency is exactly the same way we do it for any other investigation.
So if they're pretty much the same, why is it a need for the title live if they're pretty much the same?
It was just a term I used to say this was the first investigation we've used it in.
So were the other cases just pretty standard cases then, not live investigations?
They were training examples that came from actual investigations that those agencies gave permission for their case files and their data to be shared as a training example and to recreate their examinations.
So they weren't active investigations to the best of your knowledge?
Correct. They were adjudicated.
So this time that you used this technology was the first time to your knowledge that it was during a live investigation?
Yes.
So would it be fair to say that that's like the first time it's being used?
In the city of Waukesha or in general? I'm not sure I'm understanding.
Is it fair to say that this specific investigation was the first time that you've used it?
Did I personally use the software or that
Yes.
somebody has used it?
You.
This was the first time I personally used the software, as our agency recently purchased it, and this was the first case we were able to use it on.
And so would it be fair to say that usually anyone's first time using new technology, there would be a learning curve? Would that be fair to say?
I would say no.
So you would say you came right into using this new technology the first time you've ever personally used it and knew exactly how to work it?
I would say over my career, especially with conducting digital forensic examinations, I had over 1,500 hours of training in various aspects. I'm a certified trainer. I hold a certified forensic computer examiner certification through the International Association of Computer Investigative Specialists, along with other certifications as well. I obtained multiple certifications from Input-Ace, the company that put on the training for this process, for this device, for video analysis. And we tend to follow principles throughout all the different disciplines. And the training's quite intensive, quite difficult. So over that time, you develop the skills necessary to be able to start using software, using your techniques to do these investigations right away.
So you're stating some pretty nice credentials there, but you also just said that there's some difficulty in the training. Would any of that difficulty lean towards the learning curve of working the software?
In my opinion, for myself, no.
So you pretty much can come into new technology and just know exactly how to work it. You're just ready to go.
Objection, argumentative, and
Grounds.
answered.
Grounds.
Overruled, he may answer it.
This particular, if we're talking strictly about video analysis, I attended a 40-hour class using the software Input-Ace along with forensic video analysis at the National Computer Forensic Institute, run by the Secret Service in Alabama. And then I also obtained several certifications through Input-Ace themselves. So having approximately 80 hours in training through the video software, this was not much of a learning curve, as I had previously been using Input-Ace software for approximately 2 years.
So this new technology was a variation of, well, let me back up a bit. What you're saying is this new technology was a variation of technology that you had already previously been using.
Objection. This characterizes the evidence.
Grounds.
This is not new technology.
Grounds.
Sustained as to the form of the question. You may re-ask.
Before using this technology in this live investigation, as you coined it, have you previously heard of this technology before using it in this live investigation?
Yes.
Any idea how long it may have been being used before you used it?
To my best knowledge, it's been around for several years. We first started investigating it in approximately January.
January of 2022?
Yes.
You are aware that this live investigation would have been a live investigation in November of 2021. Would that be fair to say?
Yes.
So it will also be fair to say that if your department didn't start using this technology until January of 2022, how were you able to use it in November of 2021?
This was not conducted in November of 2021. Once we learned about methods when we were trying to locate a more scientific way to do a speed analysis, I discovered this method, the training that the company put on. We had to obtain budgetary funds. It was approximately $4,000. Then we had to schedule the training. The training was supposed to be earlier in the spring, and a couple of the instructors came down with COVID, so the classes got pushed back to summer. We had been doing, they had provided me with all the online training videos so that I could go through, watch those, start prepping myself as much as I could. And then this summer, we actually had the class with the hands-on examples, and that's when they provided the certification. And after that is when we actually went out and were able to do the speed analysis based on the videos that we had from November 21st.
So the bulk of your learning to work this technology was done via video.
Video and live instruction.
And that live instruction was in the summer, as you stated, correct?
Some of it was, they don't do it all in one segment, so it was completed with an instructor between, I believe, May and the beginning of August.
So when did you, around what time did you do this analysis?
I believe I performed the actual analysis somewhere around the middle of August. I can't remember the exact date.
So pretty recent.
Yes.
Any idea why so long, considering that this matter has been going on for roughly a year?
Objection asked and answered.
Grounds.
In the last 3 to 5 minutes.
Grounds.
Overruled. He may answer.
We just wanted to make sure that we had all the proper equipment, the proper training, all the proper documentation, certifications for myself and the device before we went out and did the actual analysis.
So your department thought it would be best to hold off on the analysis until you got everything in order?
Yes, until we had the certifications to make sure they were valid.
Would it be fair to say that that's a pretty lengthy amount of time to wait to do an analysis in a case that's a pretty big case?
No, I would not say that.
Have you ever had that sort of delay before in any other live investigations?
I can't recall specifically if there's been something that delayed our analysis of another piece of evidence, another investigation, but there is a delay to sometimes purchasing equipment for a new piece of technology or a new type of training. When we start talking about digital forensics, we're talking about tens of thousands of dollars for equipment, and often anywhere between $3,000 to $6,000 for a week long of training for something particular.
So there's a delay because of the financial part of the investigations, or I'm not sure I'm getting with.
Sometimes there can be.
Any idea how that might apply to this live investigation?
I'm not sure I understand the question.
How the financial part of the equipment, and as you said, sometimes things can get expensive. Would that apply to this live investigation of why the delay was so long?
Objection.
Grounds.
Relevance.
Grounds.
Overruled. He may answer.
Yes, I believe in January, again, is when we first started looking at this. We had to obtain the funding, schedule the training, wait for the company to host the training and all those things before we were ready to proceed with it.
Do you recall who you were referred to do the analysis?
As far as
basically who tapped you to do it? I'm quite sure you're not the only person that does what you does out of your department. Would that be fair to say?
No, that would not be fair. I am currently right now the only one certified in forensic video analysis.
So who tapped you to be the video analysis for this particular case?
I was the only one at our agency that would be able to perform that at this time.
Who contacted your agency?
Detective Casey.
And who does Detective Casey work for from your knowledge?
City Waukesha Police Department.
To the best of your knowledge, was Detective Casey made aware that it would be a long delay before the analysis can get completed?
Yes, we had discussions about it.
Was Detective Casey informed that it would be such a lengthy delay? Grounds.
Overruled. He may answer.
Not initially. Again, this was supposed to be done a lot earlier in the year. However, due to the limited number of classes they have scheduled, where they're scheduled, and the fact that COVID unfortunately canceled a couple of the classes, that did increase the delay, which I did have conversations with Detective Casey about, advising him that it would be a little bit longer.
Were there any, I guess I would say, suggestions that maybe you could use a different technology that wouldn't have caused such a long delay?
Not for video analysis, no.
So what video analysis were you doing before this new technology that you just started using?
This technology was specific to speed analysis.
So there was no technology specific to speed analysis before this new technology?
Not that I'm trained in, no.
So would there have been someone else tapped to do the analysis if it wasn't for this new method?
I was concerned with video analysis, and I'm the only one at our agency that can conduct video analysis at this time. As far as other methods outside of digital forensics or forensic video analysis, I wouldn't have any expertise or knowledge to speak on those.
I'm a little confused because do you do video and speed analysis or one of the other? Because you just stated, and I think it would be fair to ask, did you just not state that this was pertaining to speed analysis?
Yes, I do video analysis for all types of cases, whatever is requested. I am trained to measure speed from strictly video analysis. I'm not trained to estimate speed through other means of investigation.
So how were you able to come up with an analysis of the speed in this investigation?
Based on the technique that I described earlier in my testimony of using the 3D scanning software, overlaying the video of the suspect vehicle traveling westbound on Main Street, plotting the points, and then measuring the distance over the time.
Was there any other method? Well, let me back up. Was there any other technology that you could have utilized that same method without a delay?
Objection asked.
Ground.
Sustained.
You stated that you've done speed analysis numerous times. Would that be fair to say?
In what regards? In what example?
To any cases before this one?
In training examples, not in an investigation done by our agency.
So it'd be fair to say you yourself haven't done very many speed analysis.
I couldn't give you a firm number of how many we did in training over that time. But no,
Not we, you. I'm asking specific to you yourself.
Outside of this current investigation, I have not currently performed any for any other agency yet, no.
So would it be fair to say that maybe you could have been off on a few of your analysis, being that it was your first time doing it in a live investigation, as you coined it?
No, I would not say that.
Grounds.
Hold on. What's the objection?
Calls for speculation and argumentative.
Grounds. Better grounds than that.
Mr. Brooks, what was your question again?
My question was that would it be fair to say that since he's stated that this was his first time doing a speed analysis in a live investigation, and he haven't done it before, would it be fair to say that maybe he could have been off a little bit on his calculations, being that it was his first time?
Overruled, he may answer.
I would say no to that. With this, again, we're following the premise of digital forensics. It's a scientific process. We learn a technique. We follow the process. We follow the standards. It's designed to be verifiable and repeatable by anybody else that would have that training and that software performant. The files can be turned over to another person with equal training, and they should be able to walk step by step and still come to the same conclusion. So I would say I'm confident in the speed that was obtained.
So if someone else can come to the same conclusions that you came to, is it fair to say that someone else a little more experienced could have been tapped to do the speed analysis instead of yourself?
We didn't have anybody more experienced in this area or our agency for this particular method.
Is it possible that a different agency could have been tapped to do the speed analysis?
This is outside of the witness's personal knowledge.
Grounds.
Sustained as to the form of the question.
Besides yourself, do you know of anybody that can do this analysis and come to the same conclusions as yourself?
I know of the company that provided the training. Other than that, I do not know anybody personally in this area or other investigators to use this specific technique.
Would it be fair to say that you weren't the only one being trained through video and the like?
Sorry, I don't understand the question.
You stated that you had to be trained in this form of doing the analysis. You stated the classes were, I think, from somewhere from May to August, you stated. Would that be fair to say?
Yes.
What I'm asking is, were you the only person that was taking those classes?
There were people from other countries, other states, wide ranges of specialties, paralegals, accident reconstructionists, forensic investigators, things of that nature.
Anybody in Wisconsin that you know of?
Not that I know of, no.
From any other departments that you know of?
Not that I'm aware of.
So it'd be fair to say that you're not sure.
I don't know who has exactly what piece of software in each location, but I have not heard of anybody else in this area having the ability to do the speed analysis through video.
So it'd be fair to say you're not sure.
As to, could you clarify one more time, please?
I was pretty direct.
Mr. Brooks,
As far,
he doesn't understand your question. That's why he's asking.
did you know of anyone else that was taking the same training to operate the same equipment and technology that you were?
Personally, no, if that's what you're asking.
So it would be fair to say that you're not sure.
I can say with confidence that nobody in the classes that I was enrolled in were from the state of Wisconsin. There were people from other countries, other states. That's really all I would know about that. I don't.
And how did you come to that conclusion?
Typically during our classes, we go through an introduction, where we work, where we're from, where we work, who we work for.
So it's kind of like, because you did state that they were kind of like video, so I'm assuming that would be online. Would that be fair to say?
It was live online training, yes.
So it would pretty much be like a classroom from an online setting.
Objection asked and answered, and I would, well, relevance.
Grounds.
It's been asked and answered, so sustain. Next question.
About how long did it take when you started to do the analysis? How long did it take from the point that you started into completion?
To put everything together, and granted, it wasn't worked on all at the same time because we had to do the camera overlay. We had to go get the readings from the variable frame light board and then start putting all that together. I would say hours wise, I would say probably someplace between 20 and 24 hours to put it all together.
So about roughly a day.
Well, work days, probably 3 days or so.
And would it be any reason why you, if you knew that you were being certified for that analysis, would it be any reason why you wouldn't start getting things in place beforehand to be ready to go as soon as you needed to be ready to go?
I had the surveillance videos that we were using from Bosco Social Club in place. I asked Specialist Platt and Specialist Schmidt to assist with the 3D scanning prior to having the last certification in place, so that everything was there ready to go once I had that certification.
So it would be fair to say that you had help in getting everything ready
with the 3D scan.
Were you at any time trained in the 3D scanning?
I am not currently trained in the operation of the Pharaoh. That's why I requested Specialist Platt and Specialist Schmidt to perform that scan.
Do you know if those two specialists, I missed the name, so I don't want to butcher them, so I'm just not going to say it, but it'd be fair to say it was two. Would that be fair? Were any of those two trained in the same speed analysis training as yourself?
No, they are trained in forensic crime scene mapping using the 3D scanner, not digital forensics or video analysis.
Would it be fair to say that even though they are not trained in the same area as yourself, that they were an essential key part to putting everything together?
The 3D scanning software is an essential function to be able to perform this particular analysis, yes.
So it would have been, it's fair to say it would have been a task if you would have had to do it by yourself.
I wouldn't be able to perform the analysis without the 3D scanning.
Did that in any way cause any delay?
No.
Do you recall about what date you started the analysis? Rounds.
Overruled, he may answer.
I believe the 3D scanning took place on the early morning hours of, I want to say, August 10th. When I had Specialist Platt and Schmidt perform the 3D scan, they went back downtown early in the morning to try and do it when there was little vehicles as possible on the roadways so that it wouldn't interfere with the actual diagram scan. I want to say the last certification was obtained somewhere right around August 16th, and then it was putting everything together afterwards.
I'm sorry, did you state the last certification was obtained around August 16th?
The last training class, yes.
So at the time that you started, you weren't yet certified?
I had not started anything as far as the speed analysis prior to that.
Why would you be starting the prep for the analysis if you were not yet certified?
Objection.
Grounds.
Sustained as to the form of the question.
You just stated that the preparations to do the analysis started around August 10th. Is that correct?
The preparations by Specialist Plata and Specialist Schmidt as to the crime scene mapping was done on August 10th.
So when did you come into the fold to start doing your part of the analysis?
My part of the analysis originally began with just simply reviewing the video, learning what video would be best, what frames I would want to use, which I obtained my training from the National Computer Forensic Institute in video analysis in April of 2021, and went back through the same training through Input ACE and was already certified through them. So I was already certified for the video analysis portion of itself. The only thing I was waiting on was the materials necessary for the actual speed calculations.
And when did you receive those materials to do that part?
The certification was obtained on, I believe, right around August 16th. I can't remember if it was that day exactly, but
it is fair to say that you had already started work before the date of August 16th.
Objection. Asked and answered.
Sustained.
So when did you actually start to do the analysis? What date was that? Grounds.
Sustained.
Do you know about the date that you completed your analysis?
I believe it was somewhere around August 23rd, 22nd, 23rd.
So it'd be fair to say roughly about a week or so?
Roughly, yes.
And do you recall when you actually turned in the analysis information?
I believe it was around August 23rd, right around there.
Do you recall who you turned the analysis information into?
I turned it into my supervisor, who then electronically forwarded it to the Waukesha County District Attorney's Office.
Any idea how long it took for it to be viewed?
No, I do not know.
At the point that you started your part of the analysis, did you still need the help of the other two people from your department?
No.
So once you started, it was just yourself?
Yes.
And you were confident that you were fully trained, you wouldn't have any hiccups working this technology for the first time?
Correct.
You were pretty sure that you would get everything on point?
Yes.
No further questions.
Hey, redirect.
Thank you. The video in question from Bosco's Social Club was recorded during the Christmas parade on November 21st of 2021. Is that correct?
Yes.
You went to Bosco's in August to obtain that video, correct? Or I should say you obtained that video and then in August conducted your speed analysis with it, right?
Yes, that's correct.
August of 2022.
That's fair. August 2022. I stand corrected. Correct?
Yes.
Okay. If you were to clean slate, take that video file, start your calculations here today, would you come to the same conclusion in terms of miles per hour over those 26 frames?
Yes.
Objection, hearsay.
Overruled his answer, my stand.
The software that we're talking about is called Input ACE.
Correct. It started off Input ACE, and I believe it was the earlier part of this year, Axon. They also make tasers, body cameras, things like that. They purchased the company now. It's called, the software is called Axon Investigate. At the start of this, it was called Input ACE.
You're certified to conduct speed analysis using that software?
Yes.
This case is not the first time that you use that software, is that correct?
Correct.
Overruled. You asked him questions about that, so he gets to redirect. You may answer.
Correct.
You use the software to conduct speed analysis on prior occasions, right?
Yes.
As part of your training.
Yes.
Your training involves using the Faro 3D scanning tool, correct? Well,
no,
that was not
He
stated.
hasn't provided the answer. So rephrase your question, please.
Sure. During your training to use the Input ACE software, did you follow the same procedure in terms of using the Faro 3D scanning?
Objection. That's hearsay.
Overruled. Not hearsay. Go ahead.
The procedures were the same, however, during training examples, throughout the country, there's different 3D crime scene scanners out there, Trimble, Leica, Faro, Total. They use various different ones during the training examples of what they had set up. The software worked similar, the methods were the same, regardless of which 3D scanner you use.
Okay. And as a result of that training and the multiple times that you used this software to conduct speed analysis, you obtained a certification, correct?
Yes.
Okay. Are you the first person to testify about speed analysis using the Input ACE software in any court in this country?
No.
Objection.
Overruled. His answer may stand.
So when reference was made during cross-examination about this being new, air quotes, software or new technology, is that an accurate description of the technology?
No.
Objection. I was referring it to it being new to him, strictly to
Your
himself.
objections noted. His answer may stand. Next question, please.
Is this this technology, the software program Input ACE, used exclusively by law enforcement?
No, it is not.
Who else uses it?
Accident reconstructionists, insurance companies, defense attorneys, law enforcement. It's available to anybody that provides payment, goes through the training, things of that nature.
That's all I have. Thank you.
All right, thank you. You may step down.
Thank you.
All right, this will be a good opportunity for an afternoon break. I'm going to keep it a little bit shorter, hopefully about 10 minutes for the jury and the parties. All rise. I'd like to wrap up today. Another request, since we were only able to secure one interpreter, would be to put to have a different witness in between the two so that the interpreter has an appropriate break. Okay, understood. And then, of course, it will also require us to be mindful of when we take the lunch hour, since the interpreter is available from 12 until 3:30. The record. All right, we are officially back on the record. Then appearances are as they were before. We'll bring the jury out, and then the state may call its next witness. So go ahead.
Perfect time for the record to address their subject matter jurisdiction, Your Honor. Perfect time.
The
What?
request to address it is denied.
Is that a judicial determination, Your Honor?
It's denied.
Is that
I'm not going to address it right now. I've addressed it previously. There's no new information. Denied.
Is it a judicial determination you're making, Your Honor?
The record speaks for itself.
Can it be filed in a motion?
I don't understand the question.
Can I file the motion that I've been
I'm not going to
raising?
answer that, sir. I'm not going to direct you to file something or not file something. The jury's coming out.
Is that a judicial determination, Your Honor?
All right.
Tacit agreement. It's a tacit agreement.
All right, thank you, everyone. Please be seated. Statement called. It's next witness.
Thank you. The state calls Deborah Ramirez.
Good afternoon, Ms. Ramirez. If you would please make your way to my witness stand, which is to my right upper riser. When you get there, please remain standing. Raise your right hand, and then my clerk, Teresa, who's all the way across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please be seated. The first thing I will ask you to do is to state your first and last names for the record and then spell each.
Deborah Ramirez, Debora, last name Ramirez.
Thank you. Go ahead, your witness.
Thank you, Ms. Ramirez. Where do you live? What city?
Waukesha.
Okay. Are you familiar with the annual Waukesha Christmas Parade?
Yes, we go every year.
Okay. So were you there last year, November 21st of 2021?
I was.
Who were you there with?
My boyfriend, our 4 kids, and my dad.
Okay. Was one of those kids a 12-year-old?
Yes.
What is that child's name?
Isaac.
And what's his last name?
Foglia Ramirez.
Do you remember where you and your family were seated during the parade?
I can't remember the exact street name. We were across the street from Chef Pam's kitchen.
Do you know if you were on Main Street?
Yes.
Do you remember what intersection you were near?
I can't remember.
Okay. May we please display for the jury and the witness exhibit number 15, which is previously published.
Go ahead.
We zoom in a little bit on the 5 points intersection. Okay, do you see the screen in front of you, Ms. Ramirez?
I do.
Do you see a green box with your name and Isaac's name in it?
Yes.
Do you see a black line connecting that box to an orange star?
Yes.
Are you familiar with the area that this map represents?
Yes.
Okay. In terms of the Sunday afternoon of the Christmas parade last year, is that orange star an accurate representation of the approximate area where you and your family were watching the Christmas parade?
Yes, it is.
Okay. Do you remember anything significant or out of the ordinary happening while you were watching the parade?
At one point during the parade while we were watching, I remember my boyfriend suddenly screaming, "Whoa, whoa, whoa, whoa." And then when he screams, I looked to my right, and that's when I saw a red vehicle coming right towards us.
You previously said that you were across the street from Chef Pam's?
Yes.
So you would have been on the south side of the street?
Yeah.
Okay. Do you remember what the vehicle that was speeding towards you looked like?
Speeding.
Sustained as to the form of the question, please rephrase.
Okay, my mistake. I thought that that's what you said. Ms. Ramirez, do you remember what the vehicle looked like as it approached you and your family?
It was a red SUV. That's all I remember.
What happened as it got closer?
I froze as it was coming closer. By the time that I finally tried to move, it was already like right at us, and I was hit on my left foot, left leg.
What area of your left foot and left leg?
Objection.
It was on top of my left foot. It the tire went over my foot.
Where were you in position? Where were you positioned in relation to Isaac?
I was standing to the right of Isaac.
Okay. Did you notice whether or not Isaac was hit?
I did not until I didn't know he was hit until after it happened, that he said, "Mom, my leg hurts."
Isaac was standing next to you, you said?
Yes.
And the vehicle ran over your left foot.
Yes.
When you say next to you, do you mean Isaac was immediately to your side or in front of you or behind you or some other description?
He was to my left, standing just probably about a few inches ahead of me.
What happened after the vehicle ran over your foot?
I fell to the ground, and I was kind of disoriented at first. All I remember was hearing the vehicle speeding past us towards other people. And looking all around me, I just remember seeing a lot of people on the ground as I was looking around to see if my kids were okay.
While you were on the ground, could you hear the sound of the vehicle's engine?
The objection's noted. It's overruled. You may answer.
I remember hearing the vehicle as it was. I don't remember hearing the vehicle hitting the brakes. I remember listening, like hearing, like accelerate instead of stopping.
Did you seek medical treatment after the parade?
I sought medical treatment the next day.
Where did you go?
I went to urgent care in Pewaukee.
What injuries did you sustain as a result of the vehicle striking your foot?
I had a hematoma on my left big toe, and I had my ankle was sprained. I went to see an orthopedic doctor who said that there was tissue damage.
Did you bring your son Isaac to seek medical treatment at any point after the parade?
I did, also the next day with me.
Same location?
Yes.
What injuries did Isaac sustain as a result of this incident?
Sprain on his left leg.
I would like to project for the witness only. Actually, 36. Actually, for the jury as well, Exhibit 36, which has previously been published.
Go ahead.
And can we play this without any sound at about 30%, please, from the beginning?
Go ahead.
And we can pause there at 9 seconds. Mr. Ramirez, did you see either yourself or your son Isaac in that portion of the video?
Slightly, yes.
On which side?
On the left.
And can you describe what you were wearing?
I was wearing a pink jacket.
Can you describe what Isaac was wearing?
He was wearing a green jacket.
We show for the video, excuse me, for the witness only, exhibit 43.
Go ahead.
Mr. Ramirez, can you let me know when you see something on the screen in front of you?
I can see it.
You can, okay. Do you recognize this screenshot?
Yes, I do.
What does it show us?
I can see just a little bit of myself, but I can see Isaac on there.
Does this depict you and Isaac before, during, or after you were struck?
Before.
Is this an accurate depiction of how you looked that day?
Yes.
Isaac as well?
Yes.
Move exhibit 43 into evidence and ask to publish.
Objection. Where are they in the video?
Your objection is noted. The exhibit number 43 is received. Permission to publish is granted.
Can we zoom in on the middle left of that photo, please? Okay, just so we know what we're looking at, the screen in front of you is a touch screen. Can you use your finger and circle Isaac for us?
Yes.
And that's the green jacket you described?
Yes.
Okay, and on which side of the screen?
On the middle left.
Okay. Can you circle yourself now, if you see it? And that's the pink jacket you described?
Yeah.
Right next to Isaac?
Yes.
All right, we can clear that, please. Can we show the witness only, please? Exhibit number 45.
Go ahead.
Do you see the picture?
I do.
Okay. And what does this depict?
It looks like a picture of after getting struck by the vehicle.
Do you see either yourself or Isaac in this photo?
I see both.
And is this an accurate picture of how you looked after the vehicle struck you?
Yes.
Move exhibit 45 into evidence and ask to publish.
Can't really see.
Your objection is noted. It's overruled. Exhibit 45 is received. Permission to publish is granted.
Can you please zoom in on the middle left? Can you use that touch screen again, Mr. Ramirez, and circle where you are? And now can you please circle Isaac? Same pink and green jackets we've been talking about?
Yes.
Left side of the screen?
Yes.
Okay, we can clear that, please. Could we please show the witness only, exhibit number 40?
Go ahead.
You see the photograph in front of you?
Yes.
Are you in that photograph?
I am.
What does this show?
That shows me getting up afterwards, after the incident.
Is this an accurate screenshot of how you looked after the SUV came through?
Yes.
Move exhibit 40 into evidence and ask to publish.
Exhibit 40 is received. Permission to publish is granted. Similar to one of the prior exhibits, you'll notice there are some comments on the right-hand side. The jury is instructed to disregard those when considering this exhibit.
Thank you. Could we zoom in on the middle of this, please? Once again, Mr. Ramirez, if you see yourself, could you please circle up yourself for us? Thank you. And do you see Isaac in this screenshot?
I don't.
Okay. We can clear that and zoom back out. All I have for this witness. Thank you.
All right, thank you.
Quick objection on that last exhibit, because you just said that.
We'll take that up outside the presence of the jury. Don't let me forget.
I
All
won't.
right, then go ahead if you have any cross for this witness.
You stated that you went to the urgent care in Pewaukee the next day. Would that be fair to say?
Yes, it is.
What caused the day delay?
As I was trying to find my other child who was at the parade but not with, like, right with me, among all the other people that were injured, I was able to see how many people were on the ground needing immediate help, how much blood was on the ground at that time, that I chose to wait until the next day, since I knew I was hurt, but I did not need immediate attention as other people did.
So you had went home for the evening and decided to just go to urgent care the next day.
Yes.
So from your recollection, you weren't in need of immediate medical attention.
I was in need of medical attention, but not immediately.
Any reason why you didn't take your son to seek immediate attention?
He was able to walk out of there with me. He was limping, but he was able to walk out of there with me. So that's why we decided to wait until the next day.
Do you recall giving an interview with a detective agent?
I remember giving an interview. I don't recall his name.
Do you recall the date that you gave the interview?
I can't remember.
Was it a few days after the incident, a week, or?
It was a few days after. I cannot remember the exact date.
Any idea why it took a few days to make a report?
We were in touch right away. It just took a few days for us to set up the interview.
Did you seek to make a report the evening of the incident?
No.
Any reason why?
I was in shock.
So at the time, you didn't feel like you needed to make a report immediately? Would that be fair to say?
As I said before, I was in shock. I got home with a basically mental breakdown. So I was crying when I got home. I did not think of anything else.
You stated your boyfriend was with you that evening. Would that be fair to say?
Yes.
Do you know if he was injured in any way?
He was not.
You stated that you heard him saying, "Whoa, whoa, whoa." Do you know where he went from that moment?
He proceeded to move backwards to not get hurt.
In the videos that you saw, did you see him in the video anywhere?
I can't remember.
So it'd be fair to say that you couldn't see him in the videos that you just saw like 2-3 minutes ago.
I could see myself and Isaac. I remember what we were wearing. I cannot remember what he was wearing.
Any reason why you remember what you and your son was wearing, but not your boyfriend who was present with you at the incident?
Because I'm the one that dresses myself and my child. I don't know what he wears at that time, at any time.
Do you remember seeing him directly after the incident?
I do.
Did he leave with you when you left to go home?
He did, yes.
And you were also there with other children
Yes.
of yours, correct?
Yes.
Were any of those children hurt in the incident?
Just scrapes from moving out of the way, but not hurt by the vehicle.
So they weren't struck by the vehicle to your knowledge?
They were not.
Do you recall where they were when the vehicle passed you?
Where they were exactly when the vehicle passed, I know that they were to the right of me. I believe they were behind me at the time.
Do you know about how far approximately from you they were?
I do not.
Do you remember if you were next to an intersection or a cross street?
To the left of me, there was an intersection. I was not directly at the intersection as there were more people to the left of me.
Do you remember what intersection that was?
It, as I have stated before, I can't remember exactly which intersection it was. I just remember being across the street from Chef Pam's kitchen.
Do we have exhibit 15, I believe it is?
Yeah.
Can you pull that up for us?
Permission granted.
Can you zoom in a little bit?
We put up on the big screen, okay?
Oh, okay. I'm sorry.
It comes up on our screens prior to anyone else, so. There you go. Is it zoomed in enough?
Yeah. Can you see the screen right now in front of you?
Yes.
Can you make out your names on that screen?
Yes,
Can you see the black line pointing to a star?
I can.
Where would you estimate that is?
That looks like it's on Main Street and Broadway.
So it would be fair to say that that cross street was in fact Broadway?
Yes.
Can the record reflect that the cross street of Broadway is identified?
Okay. The record will so reflect.
Do you see the red line right there under the star inside of the police badge emblem?
Yes.
Do you know what that red line indicates?
I do not.
Do you know if there was a barrier at that intersection?
I remember seeing barriers. I cannot recall if there was one at that intersection.
Do you recall where you saw the barriers at?
I don't recall.
Did you see the barriers anywhere in your vicinity, your immediate vicinity where you were stationed at?
Like I said, I can't remember.
Do you recall when you first, oh, you can pull this down, I'm sorry. You can take that off screen. Do you recall what you were, oh, let me back up. Do you recall seeing the vehicle approach?
I do.
Did the vehicle strike that? Were you able to estimate how fast the vehicle was traveling at that point when it was approaching you?
I wouldn't know how fast it was traveling.
Did you make out the make and model of the vehicle that was approaching?
All I remember is there was a red SUV. I can't remember I wasn't able to see what the make and model was.
Did you see the driver?
I did not.
Were there any tints to the vehicle that you recall?
I can't remember.
Did you catch the license plate number?
I did not.
Did you observe the vehicle strike anyone before it got to you?
Yes, I did.
After it passed you?
Before it passed me.
After it passed you?
Why don't you ask the question more fully so it's clear?
Did you observe the vehicle strike anyone once it passed you?
I did not.
Do you recall your boyfriend taking a video of the incident?
Yes, I do.
Have you seen that video?
Yes, I have.
Was that video given to any law enforcement that you recall?
It was not.
Any reason why?
Because when the vehicle came towards us, it was moving way too much because of him moving back, and it was too blurry to see anything.
So it would be fair to say the video was pretty much disregarded at that point.
Yes.
Any reason why it would be disregarded?
You could hear the screaming, but as I said, you cannot see anything.
So it was it's fair to say it was disregarded because the video, in fact, could not, you couldn't see anything from the video?
Yes.
When you and your son were treated for your injuries at urgent care in Pewaukee, about how long did the treatment last before you were discharged?
We were there for at least an hour.
Why so briefly? Grounds.
Argumentative, sustained.
Were you given any pain medication during your treatment?
Objection, relevance.
Grounds.
Overruled, she may answer.
I was not.
Do you know if your son was given any pain medication at that time?
No, he was not.
Do you recall it being pretty loud out there that evening?
Yes, I do.
Pretty windy, pretty cold?
I can't remember.
It'd be fair to say it was chilly enough to wear a jacket or a coat. Would that be fair to say?
Yes.
Would it be fair to say that maybe it was windy enough to wear a winter cap?
Yes.
Do you recall if you were wearing a winter cap?
I do.
And do you recall if you had it pulled low, possibly over your ears?
No.
You don't recall? I'm sorry, I didn't know what the no was to, that's why.
I was wearing a headband. I was not wearing a cap.
It'd be fair to just say that you just said you was wearing a cap.
No, you asked if I recalled if I was wearing one. I said yes, I recall.
That you were wearing a cap.
I recall if I was, and it was a winter headband.
I might have been confused. I apologize.
Ask the next question, please.
I don't consent to that now, Your Honor, for the record. Do you recall if anyone else you was with was wearing a winter cap?
I don't recall.
After your initial treatment at urgent care in Pewaukee, did you receive any more treatment after that?
Yes, I did.
Did your son receive any more treatment after that?
He did not.
No further questions.
Any redirect?
On cross-examination, you testified that you saw other people get struck before the SUV got to you and your family, right?
Yes.
What group in the parade was in front of you at the moment that the SUV got to your family?
Extreme dance.
Did you see those girls get hit?
I did.
Did you see the aftermath after the SUV went through that area?
Yes, I did.
Based on what you saw with those girls getting hit, if you and Isaac had been standing 18 inches to the north, do you think you would have delayed until the next day to seek medical treatment?
Objection, that's subjective.
Sustained.
I don't have anything else for this witness. Thank you.
All right, thank you. You may step down. All right, we will at least stop with testimony for the day. I do have the instruction to read to the jury. And then once I'm done doing that, you'll be excused for the day. Do not begin your deliberations and discussion of the case until all the evidence is presented.
They are not trained in the same area.
8:30. All right, thank you. Please be seated. All right, Mr. Brooks, I cut you off because I wanted you to raise whatever the issue was outside the presence of the jury. I don't know if you had a question or an objection or a comment, but go ahead.
I forgot what part you cut me off on.
Well, it had to do with the one of the exhibits, and it's the second time it's happened where I've told the jury to disregard comments that are visible on the exhibit.
Yeah. Is it a way that I mean, because that was the one that was the steel frame, right?
Correct. We've seen it before on the video.
Can they cut that part out so that way just make it easier?
So at this point, the exhibits have been received. I've told them to disregard it. What may happen is ultimately when they're deliberating, they may ask to see exhibits. And if that happens, then I'll have to make a determination about whether those exhibits are given to the jurors. There might be copies that are there, or shown if that's the type of exhibit we're talking about, and then we'll go from there. So it's a little bit premature, but I hope that answers your question.
I do believe you were more than clear when you told them to disregard it. So that part was definitely cleared, and the worry would be if they were shown that in deliberations.
We'll cross that bridge if and when it becomes an issue.
Yeah, I just don't want it to.
I understand.
Just for the record, we're talking about exhibit 40. That's the exhibit that Mr. Brooks, the defendant objected to, and then we put on a pause until the jury was out of the room.
It was exhibit 40, where I instructed the jury to disregard the comments on the right. I have a note, I'll have to look back through my notes on this happened another time, and it may have been maybe the same.
I think it's the video that the screenshot came from.
Exactly. All right. Then, does the state have any information for me about the witness and whether you'll need the interpreter for tomorrow?
No, we do not believe we will need the interpreter for any of the state's witnesses, Your Honor. We did secure Juan Marquez to be here at noon, so that as soon as we start from the afternoon break, we could take his testimony out of order.
All right. Mr. Brooks, do you understand that?
No. But
well, let me advise you, sir, that since there's the need for an interpreter, and this court had been going through making, not myself, but the clerk's office, to make arrangements as it relates to this interpreter, I'm going to have you call that witness. It will be out of order. That's not unusual. That happens sometimes, but we at least have that witness available starting at noon. If all goes well, we'll take an early lunch about 11:30. We'll take an hour, and then we'll put Mr. Marquez on at 12:30. You'll do the initial questioning. The state will then do the cross. Okay? Did you hear me advise you of that?
I'm informed.
All right. And then the other thing I just want to put on the record today is that, again, Mr. Brooks does not have the headphones on. I did not notice any apparent difficulties with your hearing. I wanted to also make a record that, especially as it relates to the cross-examination of Detective Carpenter, which I would describe as a technical expert witness, there was some very articulate, clear, cogent, and salient questions were asked by Mr. Brooks, especially regarding when the technology was obtained. He questioned him about such topics as it was a live case and what that meant, the reliability of the software, the equipment, even the financial issues, not issues, but just how it was obtained, his training, his experience, asking questions regarding did he provide, for example, speed analysis for any other cases and things of that nature. You're certainly questioning other witnesses about whether they've watched videos previously that would go, to their credibility, which is ultimately a jury determination. But I just wanted to put that on the record and commend you for that. Any other issues from either party today? From you, sir?
We still got the issue about the 13th subpoena.
So my understanding is you filled it out, or do you need to fill it out?
It's been filled out. I
Has it been?
just wanted to know. I didn't know when it was going to be addressed.
So
And
my understanding, and let me confer with the state, did the subpoena get turned over to the state? The
I don't-
13th subpoena.
I don't believe it has, no.
It's the witness is the one who the state previously advised us was lived out of state. That's the person we're talking about, correct?
and that's the issue.
So the state's not obligated. I'm just going to cut to the chase. The state's not obligated to make any kind of travel arrangements or otherwise serve the subpoena on someone who's out of state. There's procedures in the statutes. I'm not going to lay those out for you. this is one of those things. I'd refer you back to when we went through the waiver of right to attorney form and about how the court can't explain procedure or the law, that you're put in the same position as an attorney who's been practicing here in the state of Wisconsin. I am not going to require the state to make arrangements for an out-of-state witness. That falls on you.
For the record, I have to be licensed to be held to the same standard as a licensed attorney. I don't want to get into that because I don't want you to think I'm trying to argue.
I disagree with your legal assessment, sir. So your
Well,
objection's noted for the record.
Well,
But you're a party to this case, sir, and parties that
I
are
don't
self-represented can do things that attorneys can do. A party doesn't need an attorney, for example, to secure a subpoena. So with that, I believe that addresses the 13th subpoena. Any other issues?
I intended to have 13 witnesses. So if I'm not obviously not able to call the 13th witness, how do I get my 13th witness?
I can't answer that, sir.
Would I still be able to have a 13th witness?
You have to name the person. The due date was on Monday. So who would be your 13th witness then, sir?
I would have to look on my original witness list to get the 13th witness. I know that was my target, was 13.
Well, I'll tell you what, I'll let you look through that tonight and you can advise us in the morning. And if the state wants to object, they can advise me then. But you're going to have to fill out another subpoena then.
That's fair.
And
That's fair.
I can't promise that they'll be able to do that, but we'll see what they have to say tomorrow morning.
Yeah, I do want to state also for the record, why I'm able to hear you very well is because I'm actually in the courtroom with you, which I have been the last few days, which is a breath of fresh air.
I would agree with that assessment, sir.
That's why I'm able to hear much more clearly.
All right. Thank you for making that record. I appreciate it. Any other issues from the state?
Nothing, Judge, thank you.
All right. We'll see everyone then tomorrow morning at 8:30. We are in recess for the day.
So hilarious. Like, really? I have 13 witnesses. How am I supposed to get my 13th witness? Yes, her father, definitely. Donkey. So we got through day 4, part 2 of DB, right? And I'll cut that up and I'll put it in its section so it can be in its own little playlist. For anybody that we were kind of waiting to see about our dismemberment trial that's coming out of Georgia. They have seated the jury and we will be live in court day 1 tomorrow. So they did not go into opening statements, you know, which was kind of to be expected, but we figured we would hang around anyways and do some stuff in the meantime. I am still checking in regards to our retrial for our mama. Court TV has put it up on their website. That they're going to be covering it. And that jury is also being seated today. So I'm not sure if they are finished with the jury selection for that one just yet. But I will send out the marker just in case, the notification just in case we jump into that trial tomorrow too. So we'll cover both of those. Hopefully we'll get coverage on both of those and be able to rock it out. I know, I'm so excited. Okay, you saying Law and Crime has which one, OnlyFans? Both of them or which one? Oh, Nicholas, okay. You know what I wanted to ask y'all? Because this is the case that we gonna cover. And I hope this is not like, I know we be all over the place, right? And y'all know everybody having all these hearings, everybody just doing the most out here in these streets. But this is a case that I plan on covering. It's not going to happen to October. I'm not sure if any of y'all have followed this case. It's with the 13-year-old girl, Naziah Harris in Detroit, where her uncle, this case is such a mess. But we will look at the preliminary hearing when it gets closer to the October date. But he had a hearing today. And I was just looking at the highlights for it, but that's coming up in October. If he decides to continue to take it to trial, it does appear that he is. I don't know. But this one, her body was never located. So like I said, we got a whole bunch of juicy ones coming up. Yeah, and they still haven't found this little girl's body. And this was his niece. He was married to her aunt. So I'm gonna pull up Law and Crimes feed. Yeah, that one is gonna be the preliminary hearing. I don't know if you've seen it, Fowler, but woo. That one, wow. Not sure. Yep, so which case is in October? That's going to be the Jarvis Butts one, and we're going to do we are going to do a review. He did have a preliminary trial to show all the evidence, and that's when the judge decided that they were going to go ahead and let it go to court, go to a full trial. So now I just seen that they had a preliminary hearing this morning on some phone documentation. So it just made me want to bring it to you guys' attention of something that we're going to be covering in October. So yeah, so we got that coming up in October. And then tomorrow I am going to work on tonight on how to be able to stream in two different what is it that I want to do? I want to stream in two different windows or two different platforms. That way I don't have to worry about my mic muting problem that we had last week when we was in all them different courtrooms. So I'm going to try to get that together, and I'm going to stagger our trial coverage if the other trial starts tomorrow. We know that the dismemberment one in Georgia is definitely on, right? I just don't know about this retrial one, but I did send out the alert just in case. Right? So just in case we need it. Yeah, and I'll check out Law and Crime to see exactly what we have going on there and see which one is going to make me happy with the stream. I don't know. I almost think I should give Court TV a break. I don't know. Did any of you guys listen to the sentencing for that guy, the first date unaliving trial? The uncut Law and Crime version? Boy, oh boy. You talking about, I wouldn't have played it on stream. I couldn't have played it on stream. I mean, I guess I could have played it on stream, like whatever. But I could have I've never seen a judge give they had to keep taking the microphone from the mama. I was in the car listening to it, and I had to park. Oh, Pretty Brown. I don't know why they don't let people speak out the way they let this mama speak out on this day, but baby. I said, I don't see why she can't speak out when she's speaking to the man that actually unalived her daughter. Like, she should be able to speak out any way she feel. Any victim should be able to say exactly what they want to say to that person. Like, oh my goodness. It was a good trial, OnlyFans. I watched it before, of course, before I was streaming. But to see that sentencing, I want to play it so bad. I don't even know what they'll do, but oh, it was so good, Father. I was like, get him, girl. I didn't even know she had it all up in her like that. She called him I'm telling you, you definitely should watch it. I mean, I would play. I don't know how to beep nothing out. So, hey, Melanie, welcome. Yeah, if I knew how to beep stuff out, or if I could catch it, I would play it. I don't know. Do I get in trouble for playing it? Oh, you say 10 witnesses a day, clear audio, good attorneys. Yeah, I did hear that part, Jules, but I ain't care after the mama got up there. So, Fowler, can I play it from Law and Crime's website, even with the language? I mean, I ain't got much going on anyway, so I mean, I can just put it as it's not my. I mean, it ain't like I'm. Oh well, let's play it. Shoot. Oh wait, I was in the car like, oh my lord, oh my. Wait a minute. Let me find it. Let me get it up here because I sure listened to it the other day. I was gonna make a side-by-side video of it. Hey Mason, welcome. Let's see, let me get it up here. You talk about a mama saying exactly what she feels. And I want them to start letting these parents and people that's going through this, like, you should be able to get it all off your chest. Say it with your chest. Oh gosh. Oh, wait. I don't even know if I want to watch the whole thing. Do y'all want to watch the whole thing? Y'all think we should watch? Oh, we about to watch it. Do you think we should watch the whole thing? I wasn't all that into the sister statement. Like, I didn't. Once I got to the mama statement, I was like, shh. I replayed it about 2-3 times. Let me just see if I can find a full thing. Only because I love y'all. Yeah, the sister statement was, I mean, it was okay. It's kind of. I won't go into I won't play the counts part. We'll just kind of go into the. I don't want to do Court TVs. Court TV is lying with it. No, you get it. You get all of it from Law and Crime. Law and Crime didn't bleep out not a word, and that was my type of action. I mean, oh. Let me find Law and Crime. This version. It keep want to give me Court TV's version. I don't want Court TV. We don't want you, Court TV. Let me see if it's in my history. Wait a minute. Oh, yeah, here it goes. Oh, yeah, it's in my history. I know I listened to it. I was like, well, shoot. I said, I want them to start letting people, when they going through stuff like this, let them get that off their chest. There are two, Lon and oh, yeah. I don't think they met online. I think that I don't know. I just know that she was they was going out on a date, which everybody they keep referring to it as a first date, but I know she was a college student. Maybe it was that they met online. I'm not sure, to be honest. I can't remember that part. But I do know that they didn't know each other very well. And yeah, he definitely got the title of psychopath in my mind. But so I'll start off with the sister statement. So it's only going to be a total of 4 statements. So we're going to get 5 statements. We're going to get 3 statements from her family member. We'll hear her sister, we'll hear mom, and we'll hear her dad. And then we'll hear Maxwell's dad. And then he had the nerve to get up there and open his mouth from his table, his mouth open. Needless to say. Now, why he didn't keep his mouth closed and zipped, I have no clue. But he decided that he wanted to open it. Whatever. Yeah. Oh, that mama statement was good. Oh, okay. I can't. Okay. I really want to skip over the sister statement, but I'm gonna let y'all see it just because.
Good morning, Ms. Reams. In order to begin, would you please state your first and last name and spell both for the record?
Adriana Reams, ADRIANNAREAMS.
Ms. Reams, what would you like to say?
When Maxwell Anderson murdered my sister, he redefined my definition of misfortune. No amount of financial hardships, disputes, or everyday struggles were even in the same realm as the effect of the loss he created. He made it,
And try to go slow, okay?
He made it to where my grandfather, who had just gotten diagnosed with cancer, lost his will to live his already health-threatening life. He was mentally sick and constantly bedridden. He could not even garden, which is a core part of his life that I have seen him do every year that I have been alive. He made me witness my hypersensitive grandmother on the verge of heart attack several times. Breaking down from the combination of the grief, other people's emotions, and the stress of having to deal with all the tedious responsibilities that he left behind when he ended my sister's life. He stole my father's ability to see the work he put in to raise Sade for 18 years, paid off by having more than a year of seeing her be a happy, successful adult who still loved and appreciated him. He stole her father's ability to repair his relationship with her and be as close as they once were. He stole my mother's chance to ever finally become the mother that Sade always deserved. But most importantly, he stole Sade's chance to be an adult, to choose who she would and would not let into her life, to prioritize herself for the first time and do what makes her happy. As a result of his actions, I have had to grow up way faster than a 16-year-old should have to. I had to communicate with law enforcement, take care of my family, physically pick my mother up off of the ground, on top of trying to deal with my own loss, because he left them all too weak and broken to do anything. I had to quit my job because Sade got me that job, and the whole time I was there, I worked with her. I saw the effect she had on people, the way everyone lit up from her presence, the way she made everyone, from customers to coworkers feel special, which meant that I had to watch all of that go away. I had to watch and hear time and time again all of the people, many of whom I've never heard of, who were deeply pained by the loss of Sade because of what she meant to them, because of the way that she changed people's lives and generated happiness and erased people's bad days with her smile or her laugh or her hugs or her compliments or her taking things off of other people's plates regardless of how full her own was. I could not continue to be surrounded by people who hurt the same way I did because of the huge impact she had on them regardless of the extent of their interactions. I could not be in places where I could easily be walked over because I no longer had her to advocate for me, as she always did when I had not yet found my own voice. I couldn't go back to a job where I could no longer be getting to spend time with her, whether it was through car rides, shifts together, or sleeping over at her apartment because she always wanted to take care of me. He made it to where I couldn't go to school without people giving me looks of pity or no longer knowing how to interact with me because neither them or I knew what to say, for there was nothing you could say for what he did. He made it to where I cannot ride my bike without random but kind strangers stopping me because they feel the need to pray for me and my family despite not knowing us. He made it to where I cannot trust anyone, not just emotionally, but I cannot meet any person without the fear that they're gonna harm or kill me. Because all my sister did was meet someone, and as a result, he ended her life. He stole my ability to feel momentary happiness without feeling guilty for enjoying my life when I know Sade will never get to enjoy hers. He made it to where I cannot let myself stop doing things because I know that if I have time and space to think, I will break down and I will not be able to start again. He made me miss school and sports and a number of other things because I was searching for my sister's body that he unremorsefully hid from us, knowing that it would cause us extra pain. He made me feel extra anger for the fact that he could be so ruthless and relegate my sister, who took years to build up the confidence to feel like something, back to nothing. He makes me feel extra anger because he still shows no regret and sits here looking stupid without an ounce of guilt for what he did. He stole my sanity because I will spend the rest of my life searching for answers that I'll never get about what he did to my sister and why he did it. Because even though he has no life ahead of him, he still refuses to tell us these answers, even though doing so no longer has any ability to hurt him. He stole my resolve when he and his lawyers sat here and tried to paint my sister as some dirty, irresponsible drug addict or dealer, which could not be further from the truth. A couple of months ago, one of Sade's old teachers gave me a letter that she wrote to me for a school assignment when she was 15. She talked about some of her hardships, and she had so many, which is why it is especially hard to know that as soon as her hard work allowed her to escape many of them, her life was stolen. She said that she wants to be my role model and show me that anything is possible, that she wants to guide me through everything and be my support system. She said that even 5 years ago, she wanted to inspire me to be as independent as she was, and that she hopes she inspires me to do what I want to do in life. She said that everything she does is for me, and she will do anything for me. Even in her 19 years, she was still incredibly hardworking, independent, kind, supportive, selfless, resilient, and special. She continues to inspire me for the fighter that she was, but he took the guide and support system and role model that she was going to be for the rest of my life. He stole my big sister that always protected me and nurtured me and put me first. And he robbed her of her ability to do that and feel accomplished because she knew she was setting me up for a life better than the one she was forced to struggle through. He made it to where I cannot read that letter that I should have always cherished and smiled about without crying, because now it is just a reminder of everything I no longer have. He made it to where I cannot speak about her without breaking down or think about her without shaking, to where I cannot even grasp or understand my emotions because they are so overwhelming that I have to be numb to them. He made it to where holidays are no longer a celebration, but a mourning. He robbed my future kids of the opportunity to have cousins and an aunt to love and support them. And I will never not be haunted and affected by all that he took from me, But what hurts 10 times more is all that he took from her. Sade deserved to be selfish and irresponsible. She was working from the time she was 14 because she did not have anyone she could comfortably rely on, and she felt the need to be self-sufficient. People only ever took from her. They took advantage of her because they knew how kind and generous of a person she was. As she grew, she began to stand up for herself, but she never stopped showing people grace, never let one or a few bad people ruin her open-mindedness and magnanimousness for everyone she met. As she became more comfortable after saving up hard-earned checks and tips for years and buying her own car and apartment without any help from anyone, she began to dream bigger. She was able to think about more than just getting by and develop career aspirations while remaining responsible and paying all her bills months in advance and still affording to finally enjoy the little free time that she had. Whether it was saving up for big vacations where she could go meet new people and experience new cultures as a social butterfly that she was, or taking a little breather and going out on one of her rare nights off between being a full-time college student on top of working over 60 hours a week between 2 jobs. She had every right to, and no matter what picture anyone paints, she was always responsible when she did. Her independence was finally allowed, and she was finally beginning to be happy. He ended it as soon as it started. He made it so she went through 19 years of hardships and abuse, and then after working hard to escape it, had no life left to be able to enjoy it. No chance to learn from whatever normal minor mistake she made as any 19-year-old does. All she wanted was to be cared for and praised and appreciated, the way she had always done for everyone else, and he instead took her ability to do anything. She was the definition of a fighter, the definition of resilience. She never laid down or backed down, and to know that he took all her power away and stole her ability to fight for herself is the worst thing imaginable. There is nothing that can justify what he did to her, and what he did was much more than just murder or dismember her. He erased her independence, her ability to fight for herself. He tried to erase her existence and her value. Now I no longer have the opportunity to try and give her everything she gave me. I cannot show her how proud of her I am or how much I looked up to her. But much worse than me, she can no longer make herself proud or make herself anything. And the only one who took that from her is the man sitting right there. I beg you to not let this man have any type of parole. You heard his ex-girlfriend describe the psychological abuse and self-harm he tried to impose on her. His behavior is clearly a pattern, and there is no way that after he has demonstrated the extent of what he is willing to do to a person so casually, he should ever walk these streets again. He still refuses to even admit what he did, and the jury and the public did not even have to be there to unanimously know what he did. He is clearly a danger to the public and should never be given another chance to cause anyone such tremendous harm the way he has done to my family. These law enforcement officers and prosecutors worked countless days working to find the truth. You, us, and the jury sat here for 2 weeks hearing all the heinous things he committed. Do not let any of that go to waste. Do not let the loss of Sade go to waste. This man should never walk free again. Thank you.
Thank you, Ms. Reams. You spoke well on behalf of your sister.
Okay, so that was the sister statement. So we about to get into mom's statement. Everybody hold on to their chairs and their seats, and I don't know. I didn't expect this to come out of her because y'all see from her stature, she's small. Like, I just didn't get this from her, and you can tell from I almost thought she had a black eye. But I'm assuming it is probably just from crying and tears and just the whole effect of this. But yeah, right. OnlyFans, yeah. So I mean, yeah. Okay, here we go. I was not expecting this. I knew that they said it was bad, but I didn't know it was that bad. Not my ear hole. Sorry. Yeah, she back at it. Okay, here we go, guys.
Speaking next will be Sade's mother, Sheena Scarborough.
First off, Your Honor, I would like to start off with, my name is Sheena Scarborough, SHEENA,
Thank you. Would somebody move that Elmo to the side, please? Ms. Scarborough, what would you like to say?
I am the mother of Sade. I've raised my daughters. We are light worker people. We are very angelic individuals. For us to even be here, I'm going to have to ask. I wanted to go before my daughter because I need her to be protected by this heavy demonic energy that is residual in this courtroom, this devil and his entire demonic family in this courtroom. It's very heavy to where I can't even talk. But Your Honor, I am asking that everyone in this courtroom be protected through the white light by this devil that sits beside. My daughter referred to you as a man. You will never be a fucking man. You're a pussy ass bitch.
Ms. Scarborough, if you could direct your comments to me, please.
Yes, Your Honor. First off, Your Honor, I would like to thank you and the entire team for what we all had to endure, which was it was freaking torture to even have to be dragged through what we were dragged through. This demon and his whole ass attorney, they knew exactly what he did and what he was responsible for. They took us through extreme agony and pain. We are already dealing with so much trauma. There's no such thing as justice with what you did to my daughter and what you have done to my family. I have bust my ass for over 20 years to raise the best possible angelic light worker kids that do nothing but good. My daughter had to cross your demonic path. You plotted and planned to kill, dismember, then you disrespectfully spread my daughter across the Milwaukee like a piece of trash. How dare you? My daughter was everything. She was everything to all of us. As my baby explained, she had a different impact in each and every one of our lives. There's so many strangers and individuals in the community that I have engaged and met that she has touched and impacted. This has affected the world, the community in such extreme ways. There's no way in hell we should have even ever went through this freaking trial that you drug us through. You knew you were guilty. You're negligent, mammy and pappy, them demons. I'll deal with them later. But I want you to know that you can no longer hurt my baby. She's in heaven. She's protected. We roll deep. My ancestors roll deep. When you touch my daughter, you fuck with the wrong family. We ain't no pussy bitches, and you should have never touched my daughter. My daughter helped everyone. She fed homeless, she worked 2 jobs, everything Adriana said. The community knows who my daughter was. Everybody knows who my daughter was. How dare y'all even pull that whole shit about that meth? You will not drag my daughter's name down trying to plot and set up stuff. You gonna carry my daughter's name the correct way in her legacy. You and your family will be held fully responsible for the rest of your life. You will be eternally haunted by myself, my ancestors. I know you cannot sleep at night. They have already been at you. You will never get peace. You will never sleep. You no longer can harm and hurt my innocent baby. You took advantage of her. You manipulated her in the worst possible way. You're a coward. My daughter is a hero. My daughter is a hero. She has saved so many other women from this demonic serial killer that there's no telling how many more people that he has killed. If you had any type of decency, but you are a devil, if you had any type of core piece of anything left in your demonic soul, or if your parents, your devil parents had any type of respect, I don't even know how they could sleep at night, knowing what type of demon son they raised, and then tried to cover it up. Y'all tried to flip that house. Y'all done did so much whole shit. It don't make no damn sense. All y'all karma is gonna be a bitch. And I'm getting each and every one of you eternally. I'm getting the whole entire family tree. Know that. Your sister, all them, each member of your family tree will be eternally hunted by my ancestors. We're light workers. I don't even have to touch you. The spiritual realm already been at you. I can see it in your eyes. You can't even sleep at night, you hoe ass. Judge, I did want to thank you and the entire community, the officers, the team, Ian, Donner, this whole entire community and team has stood 10 toes behind us. This has been extremely traumatic. This is not even my character. I don't move like this. I've been advocating and helping others my entire life. I come from a mental health background. This was not supposed to happen. This was not a part of our plan. Me and my daughters had goals. They are both very academically gifted and talented. They are overachievers. For this to happen, and we have bust and worked our behinds off in life, and then to have all of this noise about the millionaire murderer's son comes and takes my daughter. I don't give a freak about what your color status or how much money you got. You ducked with the wrong family. Because I don't play. You thought you was going to get away. But I'm going to respectfully request that you confess where the rest of my daughter's crown is, if you have any respect left for me and her father and her sister and the rest of my family in this community. You've already done the worst. You can at least give us that much. You have messed the entire community up. People can't even take walks and go to the park, and everybody's in trauma. This was not your first time doing this. And all your dark is going to come to the light. If you or your devil parents had any type of decency of respect as humans with morals, there's nothing else that there's no excuse for what you did to us, what you did to my daughter. My daughter is now protected. You can't hurt her. You can't take advantage of her. But know that you messed with the wrong one. You weren't getting away with this one. You will be dealt with eternally, like I stated. But your Honor, Judge, I'm asking that this demon be respectfully returned back to Hill as soon as possible. That's what I'm requesting through the court. Please return him back to Hill as soon as possible. No possibility of life without parole, the maximum. And this devil should not be given any more special millionaire privileges being held in certain populations. He needs to be, not he, but that devil needs to be placed in a population with the rest of the demons that harm and hurt individuals, the murderers, the serial killers, the felons. You are not on no special privileges. Your money is not going to protect you. It's a done deal. Sade's justice is just now beginning, and you and all of your family will eternally pay for what you did to us.
Thank you, Ms. Scarborough.
Carlos Robinson, the father of Sade Robinson, will speak last.
You talking about a statement, and look at him. He almost got on my nerves. I don't know how you gonna ban me. Is it my noise? Is it real loud? Just to make sure y'all woke. I need to make sure everybody up.
My name is Carlos Robinson. CarlosRobinson.
Mr. Robinson, what would you like to say?
I've started my speech multiple times since the trial. My daughter was an amazing person. She lit up every room she walked into. She changed my life from her birth, literally changed my life. She gave me a reason to think more of than make me realize life is bigger than myself. We had an unbreakable bond, me and her. Talking to her was like talking to myself a lot of times. I used to tell her she was the innocent part of me. People lose their children. That's sometimes a part of life. I understand that. But to lose your child in this manner is unthinkable. No, I've tried therapy and all kind of treatments, and it's nobody can help me get through this process because everybody says nobody has ever been through this. What he has done is inconceivable. And to know that there's a chance I might not even have her completely to be able to put her at peace brings me night terrors and constant mental chaos. He has my daughter had a lot of life left to live. We talked a lot about her future. When she decided to come to live with me, and I got custody of her, I started to take her to colleges and things like that. And because before then she had no goals to go to college or anything like that. So I took her to like Howard University, FGCU, and she got the experience, and she started to change her perception of her goals and what she wanted to be and what she wanted to do. She had so much life left to live, so many goals that was taken from her. And to me, it's not just that she's not here, it's the way that she's not here. I can't wrap my mind around it. Somebody that does something like this doesn't even deserve. I think death is a way out. You deserve what you get. He deserves the punishment that he gave to my daughter. Everything that he did should be done to him. That's how I feel. To me, that's justice. I don't feel like he has a right to walk around and breathe air, eat breakfast, brush his teeth. He doesn't have that right. The moment he done what he did, he lost that. Any basic human rights. No man should be able to live doing what he did. That's just how I feel. And I try to make peace because I am a man of God, and I try to do learn forgiveness. But I can't get past this. I can't.
Thank you, sir.
So that was all the people that spoke. So glad it's going. So the state representation and charge.
The court also has to consider the defendant's character, and the court has to consider the need to protect the public. The defendant was found guilty of 3 crimes. Count 1 carries with it a mandatory sentence of life imprisonment. The only consideration as it comes to count 1 is whether or not the court makes Mr. Anderson eligible for extended supervision at some point after serving 20 years of initial confinement. The state's request and recommendation of the court today is to impose life imprisonment and not make the defendant eligible for extended supervision as it goes to count 1. As to count 2 and count 3, the state would be recommending the court impose the maximum sentences and run those consecutive to one another and consecutive to the life sentence on count 1. To begin with the seriousness of the offense, obviously the court was here for the jury trial. I want to just highlight what I think the most important things were as it relates to what considerations there are today at sentencing. On April 1st, 2024, Sade Robinson went to work at Pizza Shuttle like it was any other day. She had that job for a while. The day began like any other day. She left her apartment on Commerce Street, went to work, and then later on in the day was texting with the defendant, and they agreed to meet up after she got off work around 5 p.m. They went to Twisted Fisherman. They were there from shortly after 5 p.m. to 6:30 p.m. And then they went to Duke's on Water, Sade driving them both in her Honda Civic, and they stayed there until about 9 p.m. They left Dukes on Water. They went to Maxwell Anderson's house at 3161 South 39th Street. Again, Sade Robinson driving her 2020 Honda Civic, and they remained in his house for several hours. And what we know is that while at his house, Sade became incapacitated. She was grabbed, groped, had her clothing removed until she was removed from his house around 12:45 a.m. going into April 2nd. She was taken from the defendant's house by the defendant in her own car and driven around the county. And the defendant chose to ultimately go to what was his secret beach at Warnemont Park and dispose of Sade Robinson in the early morning hours of April 2nd. He took her body down to the shores of Lake Michigan. He cut her up into pieces and disposed of her in the lake, mostly in the lake. And then he took her car, left Warnemont Park, drove to the north side of Milwaukee, set her car on fire on 30th and Lisbon. In the course of doing that, in the course of disposing of her vehicle, he also discarded her left leg in the 31st and Galena playground, just a couple blocks away from where he set her car on fire. He calmly walked away and walked to a bus stop and returned home by a bus, Milwaukee County Transit bus, and then went about his life as if nothing happened. He went to work that day at Dugout 54. Later that night, April 2nd, Sade's right leg was found on the shores of Lake Michigan at Warnemont Park. And shortly after that, on the night of April 2nd, she was reported missing to police. For the next several days, as her family and friends wondered where she was, there were searches underway, and additional remains of hers were then recovered at the 31st and Galena playground. The police investigation allowed them to learn that the defendant was the last person she was with, the last person she communicated with, and he was ultimately arrested on April 4th. Days later, her torso was found badly decomposed, washed ashore in South Milwaukee. He had cut off both of her legs, cut off one of her arms, cut off one of her breasts, and cut off her head. Her head has never been recovered. As you can tell from what you've read in the letters and heard today, Sade was a completely innocent victim. She died alone in an unfamiliar place. Her last moments had to have been terrifying. And then after being killed, she was disgraced in the worst way imaginable, having her body cut into pieces, having her head cut off by the defendant who tried to make her disappear from the world. So when the court is looking at the seriousness of what Maxwell Anderson did, you have to consider who Sade was. She was a 19-year-old young woman, totally innocent. And as you've learned through the statements today, the PSI, hearing her friends and family testify, she was just getting into adulthood. She had just gotten that apartment on North Commerce. She had just bought that 2020 Honda Civic. It was a point of pride for her. It was it was a marker of adulthood, a marker of independence. She was ambitious. She had dreams. She wanted to succeed. She wanted to be productive. She went to school. She worked 2 jobs. And as you know, she was adored and loved by everybody, by all of those around her, her coworkers, her family, her friends, everybody. This is the most heinous crime this court will see. It doesn't get more serious than this, and it shows that the defendant has a depraved heart and he has demonstrated a total lack of remorse, lack of accountability, and the gravity of this offense supports never letting him out of prison. When considering the defendant's character, we look at, for one, his criminal record. He has 6 prior criminal convictions. They are outlined in the pre-sentence report, and I think it's worth going through some of those, all of those, and the other conduct that's described in that report to get an idea of his character, and then to look at how that behavior was reflected in what he did to Sade. In 2014, he was convicted of a disorderly conduct, domestic violence incident. There was a read-in charge of disorderly conduct. This incident involved a domestic disturbance where he became violent during an argument with his mother. He damaged some property, pushed his mother, got into a physical altercation with his mother's fiance at the time, and it resulted in that person sustaining an injury, and Mr. Anderson himself sustained an injury during that. He was convicted, as I said, of disorderly conduct, and he was given a fine. In 2015, he was charged and convicted with another disorderly conduct, a domestic abuse crime, criminal damage to property, and misdemeanor witness intimidation. There was another charge of criminal damage to property dismissed and read in. This incident also involved a domestic disturbance, this time with his grandparents, where he again became violent, threw things around, punched a hole in the wall, broke a phone. When his grandparents tried to call the police, and then he left. This time he was placed on probation and fined. He was discharged from probation. Fast forward to 2020, he was convicted of disorderly conduct. He had a dismissed and read-in count of misdemeanor battery. This incident involved the defendant beating up a man on Wisconsin Avenue when the man purportedly tried to intervene in an argument between the defendant and a female that the defendant was with. There was a video taken by a bystander that showed the defendant on top of the victim, hitting him with a closed fist in the head while the victim was on the ground trying to protect himself. Ultimately, again, he was convicted of disorderly conduct. He was placed on probation. He had previously picked up an OWI first offense, and then in 2022, he was convicted of OWI second offense after being pulled over going 70 and a 30 after 2 a.m. He was given a breath test and came back at a .145, and during this incident was also cited for disorderly conduct for urinating on the interview room that he was taken to by police after his arrest. There is a 2015 incident mentioned in the PSI. It's not a criminal conviction, it's just an operating without a license forfeiture. And then the PSI also brings about this 2010 incident where he was caught at what appears to be an underage drinking party, and after being detained became belligerent, vulgar with police, urinated in the police vehicle that he was put inside. Since being arrested for this case, he has been in the Milwaukee County Jail. There have been numerous instances of misconduct while in the jail. Some of those are talked about in the PSI as well. I was provided with approximately 21 incidents of disciplinary infractions during his time at the jail, usually involving verbal abuse to jail staff, name calling, non-compliance with the rules. There was one incident of him defecating on himself during transport after one of the days of the jury trial, and another incident where he had apparently damaged some property, an electrical box, in the jail. Generally, his behavior while he's been in custody for this case at the jail, he's been a nuisance. What I think is important to take away from all of that is that this was not an isolated incident of violence. He has demonstrated in the past that he is capable of acting violent. But I think what speaks most to his character is the depravity of what he did in this case. I think all of that shows he has a violent, dangerous character and also supports this court not giving him an opportunity at extended supervision. As far as the need to protect the public, it simply couldn't be higher here. As I stated, this is the worst kind of crime there is, done in the worst way, leaving a family and a community shattered and distraught. And the public needs to be protected from this type of behavior, and life imprisonment guarantees that. This incident had, as this court is aware, a tremendously negative impact on the community at large, on the public. The public was completely shaken by this. Members of our community, young women in particular, deserve to feel safe, deserve to feel like they can meet new people, go on a date, and not fear for their safety. And he took that sense of security away from countless people, and he does not care. The last thing I would highlight is the impact on the victim and the victim's family. Anytime there is a loss of life, it's going to have a tremendous negative impact on a family. But what happened to Sade Robinson was not just tragic, it was an unconscionably vicious act of violence that violated her dignity. He had her unconscious, was grabbing her, groping her, removing her clothing. He killed her. He then cut her body into pieces and sought to have her disappear. It was simply evil and heartless behavior. And anytime a child is lost, a family obviously is going to grieve and going to suffer. But in this instance, that loss of life was compounded by the brutality and the viciousness of what he did to her body after she was dead. And to add to that horrible reality of what they had to hear happen to her, they also have to live with the reality that her entire body has not been found. Her head, to this day, remains in an unknown location. And the fact that her head remains in an unknown location inhibits their ability to find peace, and it inhibits their ability to believe that Sade has found peace wherever her soul may be. And he's the cause of that. When you consider what her family went through, on top of losing a loved one, they had to deal with the agony, which was bolstered by the fact that they didn't know where she was missing, or what happened to her. And meanwhile, he's continuing on with his life as if nothing had happened. And all any parent or friend or family member would want to know in those moments is that their loved one is safe, or that they just want to know where they are. And it was and continues to be torturous to their family, to Sade's family, because they don't have that answer as to where all of her is, where her head is. And still to this day, there remain unknowns that will likely forever haunt them. And the family can't even say goodbye to her because part of her is still out there somewhere. And he's shown no remorse for what happened. He has not accepted responsibility for what occurred. And his failure to accept responsibility has further caused the victim's loved one pain and reinforces his heartless character, which we've already discussed and which the court must consider here today. Again, simply put, there is no more depraved of an offense that this court could see. The defendant murdered Sade, tried to rid the world of her being. It's the worst behavior any human can engage in. It shows he has no morals, no sense of dignity, no remorse, and there's only one sentence that is suitable for that kind of violent and evil behavior, and it's imprisonment for the rest of his life.
Thank you. Defense.
Thank you. We'd have Maxwell's father, Steve Anderson, start by making us saying a few words.
Sir, please start by stating your first and last name, spelling both for the record.
Stephen Anderson. STEVENANDERSON.
What would you like to say, sir?
Thank you for this opportunity. On behalf of myself and my family, I'd like to say a few things. First, to Sade's family, there are no words that I can share that will reduce your pain. You are all in my thoughts every single day. Although it is not the same, having lost a boy that was like a son to me 10 years ago, I have some sense of what you are feeling. It took me a very long time to get past the pain that I felt for the person that contributed to his passing. I'm not asking you to forgive anybody or anything. That is between you and your God. To the court, in particular, to Deputy Allen, to Judge Crivello, thank you for your compassion and all of your professionalism. To Max, we want you to know that we love you and support your plan for self-improvement. In this, we hope for a path for you to become a positive influence for society, both while you are incarcerated and hopefully after. Thank you.
Thank you.
Thank you, Judge. As you noted at the beginning, we filed much of our remarks in writing so that the court would have a clear picture of what we were asking for in this case. I know that there's no way to put a number sometimes on the loss of life. It's a very hard task that the court has whenever being in homicide court, you're confronted with homicide cases on a fairly regular basis. And by putting a number of 25 years of parole eligibility, we do not make any claim that we know the magic number. What I would observe is, in terms of that recommendation, is this. When you set, first of all, the sentence in this case is a mandatory life sentence. The jury convicted him. That's required. One way or the other, whether he's granted the opportunity to be, and I use the word parole, obviously we understand that it means extended supervision. It's often used interchangeably, but we're referring to some future hope that Mr. Anderson would have the opportunity to be released from custody. And the point of that is that he will be supervised by the Department of Corrections for the rest of his life, no question about it. And he has been in custody now, obviously for over a year, in solitary confinement, which is about as horrible of a condition as a person could ever be confined in. There are basically the unit of the jail, the unit of the jail that he's in is one where there's mental health patients, there's people who are going through substance abuse withdrawals. And so it's a torturous way to exist. Obviously, there are very real safety concerns that Max has going off to prison. We've, I think, expressed some of that in our written submissions to the court, that is a real consideration, because at the end of the day, this is not mob justice in this country. People have the right to a trial. They have the right to the evidence to be presented, the right to be represented by lawyers, and the right to test that evidence, and the jury return the verdict that it returned. And it's your job to determine the sentence. But I want to emphasize that whether you agree with our recommendation, the state's recommendation, or something in between, no matter what it looks like, Mr. Anderson is going to be saddled with this conviction and the supervision and the incarceration for the rest of his life. As he sits here, I struggle to wrap my mind around some of the case, just like everybody else. We heard the evidence. We sat through the trial, and I certainly appreciate the state reciting it again today, but I don't think any of us have forgotten it. And as you read in the pre-sentence report, I'm not going to get into the details of it, but you read Mr. Anderson's version of events. He maintains that he didn't commit the crime. And you can place whatever weight on any sentencing factor you want, obviously, but that's his position. The jury reached a different verdict. And so for purposes of my presentation, I don't think it's wise or useful to parse through the testimony and point out what I think are points of reasonable doubt. The jury rejected that and they returned the verdict that they returned. What I would say is that when you read through the character letters that were filed by Max's family, and I listened to the remarks from Sade's family as well, beautiful remarks by some of her family members, and the character letters were beautiful as well. But so were the ones on Mr. Anderson's side. Every person who has known Max throughout his life, every one of these character letters speaks to a history and a background that wouldn't suggest that something like this would happen. His mother describes how when she would come to visit him, he had adopted dogs, how they were well trained, how they were obedient, how he talked about wanting to work in a nonprofit center someday, his abilities as a chef, his work history, his imagination. And you go through the other letters that were submitted, his younger sister who had written a letter and talked about Max's intellectual talents and how he was a good student, how things came naturally to him, and how he was a good brother to her. The letter from the grandparents who were mentioned here as part of an earlier case, but his grandparents talking about their positive experiences with Max growing up. And that's the theme I think that exists here in all of the character letters when I read through them, that Max is, before he was taken into jail, before he was charged with these crimes, and before this incident took place, Max's character was generally positive. He's a high school graduate. After graduating high school, he went off to the Navy, served in the military for approximately 2 years. And I think there's obvious mental health issues in his background. I think that's clear. His mother talked about what she thinks was a traumatic brain injury that he suffered at 3 years old. There's a documented history of ADHD. And you read during his military service, the mention that was made about the suicide attempt that happened in the Navy where Max had tried to hang himself with an electrical cord. So clearly there are mental health issues that deserve treatment. And we know that prison is not the best environment for a person to receive treatment for their mental health issues and their AODA needs. I disagree with the state that there's a long history of violence by Mr. Anderson. I think there are some isolated criminal convictions, but all those criminal convictions are misdemeanors. He has no felonies. And they are all of the disorderly conduct variation. Even the one that the state mentioned about the incident on Wisconsin Avenue that was prosecuted here in Milwaukee, that was settled for disorderly conduct with probation. The incident with his mother, fine only, disorderly conduct. So that is not a significant prior record. And I think that differentiates Max from a lot of other people that come in front of this court. You do see people often in homicide court with gang ties, long histories of gun violence, long history of juvenile misbehavior, and you don't have any of that here. You have misdemeanors. There obviously are AODA needs. I think all of these cases, if you look at the disorderly conducts that he's had in his background, every one of them basically involves either mental health or substance abuse. And I think that's a recurring theme that we see here and even saw a little bit in the trial. The copious amounts of alcohol that was consumed on the night with Sade, I think further underscores that there are certainly AODA issues here. Max's plans for the future, they're, I would submit, incredibly realistic given the circumstances that he's in here. His continue furthering his education is one of his goals, writing books, continuing to learn foreign languages. So I think he does have realistic plans. And obviously the punishment that's been inflicted sitting here in the county jail in solitary confinement has been horrific. Really, there's been almost no human interaction. He sits in a cell all day. His human interaction is when a PSI author comes to visit him or one of his attorneys comes to visit him, but not even being able to have visits from your family, not be able to see people in a face-to-face manner other than the guards is truly horrible. And of course, the fear that we have of him being targeted in prison, we know that because of some of the publicity that this case has generated, and I know it's not a matter that this court can specifically address, but we would ask that as part of the judgment of conviction in this case, the court express no objection to the Department of Corrections choosing to house Mr. Anderson as they see fit. I know it's up to the Department of Corrections, but it is an important consideration in this case that even people who have been convicted of very horrible crimes, we are not a death penalty state. We're not a mob justice state, nor are we that way in this country. And I would hope that the Department of Corrections takes measures to keep Mr. Anderson safe. The compass evaluation in this pre-sentence report is certainly not as bad as you often see. In fact, most of the, and that's an actuarial instrument that is done to evaluate a person by the probation department. And it's on pages 39 and 40 of the pre-sentence report. He is rated unlikely in numerous categories of having issues with society and routines, unlikely to have any leisure or recreation issues, unlikely to have thinking and attitude problems, unlikely to have negative personality traits, even unlikely to have anger issues. And so that's those are the actuarial tools that you've asked the Department of Corrections to use by drafting this report. They come back and conclude that these are not significant issues that need to be addressed at some point. There's not a socialization problem. There's not an educational problem. And we know that from his background. You learned a lot about Mr. Anderson during this trial. He has a long work history. He's been basically a pro-social person since he went off to the Navy. He's held a variety of jobs throughout Milwaukee. People have known him throughout the community. He's been a bartender. He's been a server. He's worked for an insurance company. And so he does have a proven work history. He was also a homeowner. He was maintaining a stable residence. He was maintaining his financial obligations. And so he's not the kind of person who comes to court with such hopelessness in terms of their ability to function in society that I think we should give the life sentence for. So my recommendation, as I indicate, is for parole eligibility at 25 years. That doesn't mean he gets released at that point. All that means is that at some future date, 25 years, when he has matured and grown, that a parole board will be able to evaluate his situation and decide whether or not he should have the opportunity to be released. That's all that means. Doesn't mean he gets out at that point. He may not even get out at 30 or 35 or 40. It would be entirely up to that agency to look at his growth and his behavior in prison. What has he done? What has he accomplished? And if they conclude that that would be appropriate, obviously the victim's family would be permitted to play a role in that process as well. And they would be able to decide whether or not to release him. We're asking you for that mercy today and that opportunity for some future release. Thank you.
Thank you. Mr. Anderson, what would you like to say?
I would like to start by saying that from the bottom of my heart, my deepest and most sincere condolences go out to Sade's family, as well as everyone else affected by this tragedy. That being said, Your Honor, I took this to trial without ever once trying to make a plea deal of any kind, because I did not commit these crimes. And so I plan to appeal my convictions, while I hope and pray that further investigations not only prove my innocence, but find and deliver true justice.
Anything else you wish to say?
No, ma'am.
So relative to sentencing, I have a job. And what my job is to do is to hold you accountable. That's to punish you. It's to protect society. It's to find a way that you never come back here again, to rehabilitate you. And it's to deter others from engaging in like behavior. At the point of sentencing, I have to look at different factors. I have to look at your past record. And I'll agree with the defense that the prior record on its face is not as egregious as many cases I see in my courtroom. Quite often you see a background filled with felonies and violence. But what I said was on its face. When you look at the record as it's worked through in the pre-sentence investigation, I'll agree with the state that there are some red flags that jump out at you that, that show a level of violence that maybe it may have been a precursor. You know, when you look at the original case mentioned from Pewaukee from March of 2010, it looks like it's an underage drinking party. And when the officers come in, they find a bunch of people hiding, and they indicate they're about to do a search. And later there's people saying that they were being held in the home against their will. Kind of a weird comment to have on an underage drinking party. Ultimately, they find Mr. Anderson hiding behind an entertainment center. He's belligerent. He tells the police, "Fuck you, I hope you're proud to serve your country this way." He's then very coarse and his comments are obscene. He then urinates in a police vehicle and calls a female police officer a cunt. Inappropriate. Then we have the 2014 case that involves the mother, where officers are dispatched to a location. They enter the home, they see, they make contact with the mother. She indicates that her son was in the kitchen. Officers approach and the response is, "What are you gonna do, shoot me?" And he runs out the door. He then jumps into his mother's vehicle and apparently steals the mother's vehicle and drives off. The mother indicates that when she returned home from work, he was acting strange. He was sweating profusely. He argued, he punched a vase, he caused it to fall to the floor. She calls her ex-husband. He pushes the mother into a room and shuts the door. He prevents her from exiting. He then breaks the phone. He's continuing to scream and yell and throw things, at which point she calls the police. Ultimately, what we find is that he returns to the residence. He gets into a physical altercation with Mr. Foos. She's informed that he had crashed her vehicle into the deck at the rear of the residence and fled on foot. Ultimately, we find that the mother's fiance confronts Mr. Anderson and he throws that person to the ground. He's able to get back in the house and to prevent Mr. Anderson from getting in. He suffered 3 to 4 broken ribs as a result of the altercation. Ultimately, they have to meet with Mr. Anderson at the hospital because it appears he suffered a broken collarbone. He's convicted ultimately of disorderly conduct because he says Mr. Foos pushed him down the stairs as he tried to gather his belongings. It's interesting when you see Mr. Anderson's comment about that because he just says that Mr. Foos just poked him. Sounds like a bit of a discrepancy there. Then we go on and we find the issue with the grandparents. And the grandparents call the police and they say that he needs someone to talk to about his mental health and that he's smashing a glass in the sink, causing it to break. He goes in the basement, he punches a hole in the wall. He breaks the other phones. They have to go to a landline at a neighbor's, ultimately to call the police. It just sounds like he is to some extent out of control. He's ultimately on probation. He's given conditions of no drinking. He's given conditions of having anger management counseling. He tells the agent other people probably deserve to do anger management. I don't. He then goes on and tests positive repeatedly. To look at his explanations are ridiculous. At one point, he claims that he accidentally grabbed someone else's Red Bull that had liquor in it. But going through the repeated indication, it sounds like Mr. Anderson's the guy that does what he wants, when he wants. and he follows his own rules, not the rules imposed on him. And that's a frightening thing. You know, I read through the defendant's version of what happened. And it starts off by indicating that he was skeptical to meet with the pre-sentence investigator because he did not receive a fair trial. And there's no reason to believe that this writer's report would be fair or impartial. You know, speaking about the trial, you know, there's a constitutional right to a trial. Every person charged with a crime has a constitutional right to a trial. And we do not in any way penalize anyone for going to trial. It's also a constitutional right to be represented by counsel. And Attorney Cotton did his job, which is just his job to represent Mr. Anderson. That's under our Constitution, the rights that exist. Now, you get credit for taking responsibility. You get credit for resolving a case early. You get credit for stepping forward and saying what I did was wrong. Because usually this first step in rehabilitation is taking of responsibility. And we didn't have that here. That's why it's important to read what his version is. So you heard him say today that he didn't commit this crime. What he said about the offense was that they met for food and drinks and they proceeded to his apartment. And that's pretty much all there is to say, he said. He offered no other information as to what transpired that night. He later said that he regretted he did not walk Miss Robinson to her vehicle when she left his apartment, and he believed it was at that point she was abducted by an unknown assailant, quote, either from the alley or from my backyard, unquote. When asked how he accounted for his presence in the area where Miss Robinson's vehicle was set on fire, Mr. Anderson said that he was set up. He stated he was in the area to buy marijuana, and quote, and all it would have taken was for someone to know where I lived and where I'd be in the morning, unquote. He would not tell the writer when or how he made the arrangements to purchase the marijuana, and then instead stated, quote, I plead the fifth. He then went on to point to things that he claimed were egregious errors at the trial. He claimed that there was a video that showed the photos on the phone and that the state only played stills of the video. That wasn't the evidence at trial. Am I correct? Yes. He claims that the still photo that showed his hand grasping Miss Robinson's breast was part of a video and it was only a still that was shown. Incorrect, correct?
You're correct.
Okay. He indicated that at trial it was flaunted, the difference in age. And when I read that, I was somewhat shocked because I didn't really find that that was pointed out at all during trial. I mean, it was mentioned how old she was, but other than that, I didn't think that that was in any way an issue, and it barely even made it into my notes. So I thought my point is, I thought it was interesting how his view of reality seems different from what I find truly transpired. And I found it at numerous points during the pre-sentence investigation. You know, looking through this pre-sentence investigation, his viewpoints were very inconsistent with the reality. You know, I think the first issue relative to the mother's fiance, that was credibility. You know, it sounds like he lied to law enforcement. You know, he's asked, have you ever been involved in mental health treatment? Have you ever been in a mental health facility? Have you ever received treatment? He responds in the negative, but then we have the mother indicating that he was in an outpatient at Rogers. He indicates that he never made a suicidal attempt or had an ideology of said. But then we read about in the Navy how he was dismissed from the Navy due to a medical release, which appears to be related to the suicidal attempt in trying to hang himself. You have him saying about school, I did okay, but then you look at the history of how he did in school and his grades were pretty abysmal. And just odd things, like he talks about how he purchased the home himself for $160,000, But the mother says, no, I told the dad to buy him the home. It just seems like he has a different view of reality than the rest of the world does. So when I look at the criminal history, which I'm bound to do, it reflects low-level misdemeanors, but the facts underlying those low-level misdemeanors are replete with points that raise your concern. I next have to look at whether he has a history of undesirable behavior, and I think I've charted through what basically I found in the pre-sentence investigation. As to his personality, character, and social traits, it appears that he has had employment. That's a positive. It looks like he jumps between bartending jobs at numerous facilities. But who is a person who would do this crime? You know, what's the character underlying that? How can someone get to a point of inflicting such damage on a person, not only killing the person, but then dismembering? And then after that, discarding the body throughout the community. It's unconscionable, is where it comes down to. I did read the letters that were supplied on behalf of Mr. Anderson, and I do agree. They paint a picture of a man who helped his family when in need, who cared for animals, who went out of his way to love and support his family. But they love him, and that's clear. And that weighs on his behalf. You know, the fact that there are people out there that care and love him, that says something good. You know, quite often we do trials or we go to sentencing and there's no one here on the behalf of a defendant, which is really tragic and sad. So it says something good that a family does still care about him. I have reviewed the pre-sentence and I've taken into consideration what's stated therein. I have to look at whether you're remorseful, and I don't think you're remorseful in any way. I don't think that you have gotten to the point of taking any form of responsibility for what transpired. You know, the investigation that was conducted in this case, it was a dedication by numerous law enforcement officers to work tirelessly to put together the pieces to determine exactly what happened underlying this matter. You know, I do think that jury trials, they do re-victimize the victims. You know, it's hard to sit and watch a trial. It's hard to see the details. And it's hard, you know, not even to have known Miss Robinson, to wipe from my mind what you saw during that trial. And I didn't love her. I didn't know her, but you did. And that's a hard last thing to have in your minds. So I do understand how trials do re-victimize the victims. So when I look at the character of the defendant, I find the character wanting. When I look to the severity of the offense underlying this matter, I do sit in homicide court. And I can tell you on a daily basis, you don't understand why things happen. You know, almost every case, the victims come in and they want to know why. Why did it happen? Why did you have to do this? Why did you have to get to that point? And more often than not, there's no answer. We never know. It never makes sense. There's never do you walk away and say, oh, I understand why that transpired. It just doesn't happen. I can also tell you that, you know, I've read through all these letters and they talk about give us justice, right? Give us what's due. But I can't give you justice. There's no way you will walk out of here, no matter what I do today, and high five each other. There's no way you walk out of here and you say justice is served, because justice would be having Ms. Robinson back to you. Justice would be having her with you for the rest of your lives. And you never get that. You know, to hear about her, she was an innocent victim. You know, she was a girl that I would hope all young ladies strive to be. You know, to hear about working 2 jobs to reach her goals, to be going on for schooling and further education, but then to hear about how much she was loved in the community by almost everyone that touched her. You know, it was interesting to go through the letters because I got the letters that were from who I expected, you know, the mother, the father, the sister, the loved ones. I also got a letter from the real estate agent that worked with Ms. Scarborough. I got a letter from citizens. And I can't tell you, I really debated whether or not I would share this, but there was a letter from a citizen that doesn't know Ms. Robinson, never met her. And this is what he said, or she said, I don't know. The person signed it as Stargazer. In pertinent part, it says, Sade Robinson was not a torso. She was not evidence. She was a full, living, radiant human being. She had dreams, plans, and a future she was building with pride. She had people who loved her and that still love her, more than words can hold. And she had a right to live, to breathe, to laugh, to grow old. That right was stolen in a way so vile, so deliberate, that it tears at the fabric of what we call humanity. You, Maxwell Anderson, didn't just kill her. You carved her and you discarded her like garbage. And you tried to erase her body from this earth piece by piece. And for what? Not even you had the courage to say. You sat there in court as if you were a man. You didn't snap, you planned. You didn't panic, you dismembered. And still you offer no answers, no remorse, no ounce of dignity that you stripped from her. But here's what you couldn't take. You could not mutilate her soul. You could not silence the scream of justice. You could not prevent an entire community from rising up in Sade's name. We know who she was. We know what she could have become, and we will not let your darkness define her. To the family, there are no words that can hold the weight of your pain, but I need you to know we see you. We mourn with you. We love you. You have the right to tears. You have the right to rage. You have the right to every ounce of justice this system can give. May you feel her arms in the wind. May you hear her laughter in your memories. May you know that she did not die forgotten, she died loved, and we will remember her always. Maxwell Anderson, you are not the center of this story. She is, and she will always be. Sade Robinson lives on in light, in truth, and in love. And you will be remembered only as a man who tried to destroy something beautiful, but failed. You know, I thought that was beautiful. And I think that it shows the impact that this had on the community. You know, that took time and effort and thought. And I think it put together a lot of what the community felt. So going back to what I need to look at. In formulating a proper sentence, I need to look at the character of the defendant. I need to look at the severity of the offense. You know, to take away a child is horrific. You know, you wouldn't wish that on anybody. To have a child not outlive the parents is a horrible thing. But not only did you extinguish her life, but you hid it, and you hid her body to be found. And I can only imagine every time a news report, every time something clicked that another body part was found, how it had to just re-victimize this family, how it had to just be like another shot to their soul. I can't imagine how horrific that had to be. And yet, I wonder which was worse, the not knowing in those first days where she was. You know, I can't even think of a word, horrific. It's beyond imaginable for a parent to think of not being able to know if your children are dead or alive, and then to learn that they were dismembered and disgraced to the extent that this poor girl, her body endured, is beyond understanding. So the severity of the offense, I'll agree. It's definitely at the top of some of the worst homicides I've seen in this court. Looking at the impact on the community, I read that letter because I thought it stated to a great extent what we're here about. You know, what my job is to do, it is to hold you accountable and to punish you. It is also to protect society. And that's about how do we figure out if at some point you're redeemable? How do we figure out if at some point you will change your mindset? You will get the therapy and education to be at a point where you will be safe to have in the community. Now, part of that goes into the fact that you don't take responsibility. You know, I listened to the evidence. I watched what was introduced during the course of the trial. There is no explanation that I've heard that's valid as to why you would be walking away from that burning car. You know, those photos were not of a girl in a video enjoying life. Those photos of you grasping the breast that was ultimately shaved from her body, with her face plastered into that, I don't recall if it was the ottoman of the couch, the way that her body was positioned, there's no explanation for that. I don't need to rehash the evidence. I've gone through all my notes from this trial, and I think that Attorney Vance Prezan did a nice job of summarizing in pertinent part the details. But there's no answer that you briefly provided in this pre-sentence that makes even a hint, that even resonates with a hint of truth. So how do we protect society from a man who clearly has had darkness in his past, who engaged in behavior that is, it's the facts that you see written in horror novels. That's what we have to determine. And you know, it isn't easy. I can tell you that when you think about, is there ever something redeemable in a person? You'd like to say at some point there is. And I can tell you that at the points in life where I've come to the conclusion that there isn't anything redeemable, you know, you do think about, I think it takes away a little piece of my soul. How come I couldn't find anything good? How come I can't find anything that I can say at some point you'll be a better person? So ultimately at sentencing, considering the seriousness of the offense, your character, and the needs of society. This is clearly not a probation case. Probation would unduly depreciate the seriousness of the offense and isn't even allowable under our law. You are sentenced to a term of life imprisonment, and that is what the penalty is for a jury of your peers ultimately coming back and convicting you on first-degree intentional. In this case, I didn't see a restitution request.
We are asking for a restitution hearing, and we've pre-selected a date.
Thank you. We'll be setting restitution off to be determined at a later date. Relative to this matter, I have considered the seriousness of the offense. I have weighed your character, and as I've indicated, I find it wanting. I've also reflected on the needs of society, and are you a good risk? And sadly, you're not. As to my sentence, relative to the nature of the offense, you are not eligible for challenge incarceration. You're clearly not eligible for any substance abuse programming. Restitution will be determined at a later date. You do need to submit a biological specimen to the state crime lab and pay the surcharge thereof. You do have the right to appeal, and if indigent, you have the right to the assistance of the public defender. What you need to understand is that a notice of intent to pursue post-conviction relief must be filed in the trial court within 20 days after sentencing for your rights to be preserved. You have been convicted of a felony. You may never possess a firearm. If you do, you're looking at 10 years of imprisonment, a $25,000 fine, or both. You may not possess body armor at any time in the future. If you do, you'll be subject to 15 years of imprisonment, a $50,000 fine, or both. You cannot vote in any election. I'm going to waive all non-mandatory fees, costs, and assessments. I'm ultimately going to want payment for restitution first and foremost. So we're going to determine that on a later date. But due to that, I'm not imposing any fine. The fees, costs, and assessments will be payable during your term of confinement at a rate to be determined by the DOC. Pretrial incarceration credit.
I'll get that information to you.
Okay. So relative to one moment. Count 3, arson of property other than building. That's a class I felony. On that offense, you are looking at a fine of up to $10,000 or imprisonment for not more than 3 years and 6 months or both. Relative to that matter, the maximum is 18 months of initial confinement and 2 years of extended supervision. I am imposing 18 months of initial confinement and 2 years of extended supervision. One moment. As to count 2, which is a charge of mutilating a corpse, that's a class F felony. That means upon conviction, you could be fined not more than $25,000 and imprisoned not more than 12 years and 6 months or both. Relative to that, the maximum is 7.5 years of initial confinement and 5 years of extended supervision. I am imposing 7.5 years of initial confinement and 5 years of supervision. Relative to count 1, that is a class A felony, the charge of first-degree intentional homicide. Relative to that, you shall be sentenced to imprisonment for life. And relative to this matter, weighing all of the factors that I must, looking at the Galleon factors, considering your character, the severity of the offense, and the impact on the community, where you stole a truly shining light is what it sounds like. I am ordering that you will not be eligible for extended supervision. Counts 2 and 3 are consecutive to count 1. The date for the restitution hearing will be
September 4th at 10:30.
Have you determined?
Yes, excluding today's date, 484 days.
I will provide you with a written explanation of the determinate sentence for your review. State, what have I failed to address?
I think that's everything.
Defense, what have I failed to address?
Nothing further.
Celeste?
Nothing, Judge.
One moment, and I'll give you a copy. Is there a printer in the paper? Is there paper in the printer? You know, moving forward, just an idea, you know, Sade Robinson, she was working so hard for good. She was working so hard to achieve so much. I haven't heard a word about how she was involved in violence or any type of attack or any type of ugliness. Wouldn't it be great if we all move forward not thinking about retaliation or revenge or hunting people, but about let's emulate that spirit and move forward trying to be kind and gracious to all. I mean, that's clearly the effect she had on the community. If we all try a little harder to step away from violence and to be kind to each other, to communicate more, maybe our world will be a better place. Just an idea. Thanks, everybody.
Thank you.
So there we have it. Life without parole, right? Like, I don't even think he here. I don't think he here for real, for real. So there we have it. I want to say another one bites the dust, but I don't know if that's good. I know. Thank you. I'll see you in the morning. Morning time. Dismembered, right? Yeah, the mom was going ham. Like, I'm like, whoa. She was threatening everybody. She is mad at everybody. Rightfully so. Yes, bright and early. We will be here bright and early. It's so funny because the one trial they got starting at 3:30 in the morning and the other one is saying 6 in the morning. But who knows? I got the alert set for us for our notification. I have our stream starting. You know, I may change this. Let me see. Give me 1 second. I might change this a little earlier. Six. Okay, so it looks like Court TV and Law and Crime has it scheduled for 6. Oh, wait a minute. Yeah, they both have it scheduled for 6 a.m. That's Mountain Standard Time because, of course, you know, YouTube is very, very nice and converts the time over for us, for me, for you too, right? So long as you have your notification bell on, it'll go ding, 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 all right? And it convert the time. That way we don't have to worry about doing all the calculations. So 6 a.m. my time is probably like 9 a.m. Georgia time. We'll be in the courtroom for opening statements. The poll came back. I closed it out. We'll be doing this trial first. And I don't know. We can see how things go. If y'all want, we can, since this one starts early, I don't know if we want to stream the other one behind it. I don't know. We can just kind of like play it by ear and see how everybody feeling. Or we can start early some days and kind of, so we don't get far behind on the other one for the people that's interested in that one. But we're definitely going to take care of this one tomorrow, right? We're going to be live in the courtroom. Definitely taking it to trial. All right. I'm excited only because we don't know much. Only that little tidbit that I gave y'all earlier, but shoot, still don't know much. I'm still confused. But hopefully once we hear them opening statements, because I listen to opening statements and I want to make sure that everything that you promised me in these opening statements, you better bring it up in this trial. It better come up in this courtroom. 6 a.m. the jewels. 6 a.m., the jewels. 6 a.m., the jewels. Yeah, so it'll be 6 a.m. We'll get on, do our morning greetings, do our 1, 2, 1, 2, right? Hopefully by that time they'll start the courtroom up, and that way we'll be live. We won't have TiVo time because we going right in there. Boom, right in there. So we won't have no built up TiVo time. So we going right in. You take it how you want to take it. But we gonna be up in there. I know you'll be at the park till 7. I know that's where you'll be. You are definitely excused until after you take care of that. I got you. No worries. Woo. So we gonna have another busy week, right? I knew Florida couldn't let us down. They couldn't let nobody else live. They say can't nobody else get no more coverage. They gotta make sure that they had them a trial on somebody's channel coming out of Florida to keep Florida on the map. They just wasn't they wasn't gonna be silent. You say no Vaseline. We see where your mind at, Jason. I said take it how you want to take it. If you need Vaseline, hey, I don't know. You can take it how you want to take it, baby. Okay, awesome. So we covered so much stuff today. I'm gonna have to be clipping and chopping and all types of stuff to put this together in this stream, right? So anybody that missed our thing in our intro and our trial for the Georgia, where we reviewed over some court documents, and we also saw some of the evidence as far as the motions and things. I am going to clip that and put it in its own little video. And then I'll also go ahead and clip what information that we looked at in regards to our STD trial that's coming up. And yeah, and that'll be it, just in case we need to review any of that stuff as we go along. Exit only, right. So I guess other than that, we can wrap up for the day and we'll start early tomorrow. Okay. Y'all good with that? Yep, that's what I'm thinking. Early release. Yep, because we're gonna be here early. 5 o'clock in the morning. Where you gonna be? Outside on the corner. You better get yourself together. Get yourself together. 5 o'clock in the morning. Where you gonna be? Outside on the corner. Well, I ain't gonna be outside on the corner. I'm gonna be right here in my chair. Get myself together. That means I gotta wake up at 3 because it takes 2 hours for the swelling in my face to go down. Thanks. All right, guys. Well, you definitely know that you were in the right place today, right? Where there's no filters. No, the Jewels, that's a song. It's called 5 o'clock in the morning. Where you gonna be? Outside on the corner. No, I know we're doing 6. It's 6. It's definitely no, it's 6. hit your notification bell. It is 6. We will be online at 6, and don't be late. Nah, you said you got to take the dogs out, so I will give you a pass because you're going to be at the park. So y'all know y'all was in the right place, right? Where there's no filters, no fluff, just facts. So you could be the judge, right? All right, guys. Tomorrow morning, 6 a.m. Mountain Standard Time, 9 a.m. Eastern Standard Time, I guess Pacific Time. It's probably 8 a.m. I think I got it right. If not, just put your notification bell on. You'll be good. See you in the morning. All right, guys. See ya.